Mr. Person, I got a message that we're live streaming now.
Correct.
Okay. Okay. Have we reached the past the 30-minute delay period?
Correct.
Okay. There's an echo up. No, the echo's gone. All right. So let's begin. It's my understanding that we are now live on Mass DEP's YouTube channel. Good morning, everyone. My name is Salvatore Giorlandino. I am the Chief Presiding Officer of Mass DEP's Office of Appeals and Dispute Resolution, otherwise known as OADR, or the Appeals Office. The Appeals Office is responsible. It is an independent quasi-judicial office within Mass DEP that is responsible for advising Mass DEP's commissioner in the resolution of all administrative appeals that are filed with the Appeals Office of Mass DEP, permit determinations, enforcement orders, and environmental jurisdictional determinations. The staff in the Appeals Office who advise the commissioner on the resolution of the appeals are presiding officers like myself. We are all experienced senior environmental attorneys at DEP. By way of my background, for those who are joining on the YouTube channel who are interested in my background, I have been a member of the bar since 1986, so almost 37 years. I came to DEP in 2006 after being a trial and appellate lawyer for 20 years, including 12 with the Attorney General's Office and the Government Bureau. I have been DEP's Chief Presiding Officer for the past 16 years. The presiding officers are similar to environmental administrative law judges. They resolve appeals or assist in the commissioner in resolving the appeals through various ways, including conducting an evidentiary adjudicatory hearing in an appeal, which is similar to a trial in court with some differences. And this morning, we have scheduled here a evidentiary adjudicatory hearing in an appeal that has been brought by a number of residents from the town of Weymouth challenging Mass DEP's determination under the Waterways Act, Chapter 91, and the Waterways Regulations at 310 CMR 9, a determination that a compressor station operated by Algonquin Gas Transmission LLC in Weymouth, Massachusetts, is an ancillary facility to the hub pipeline that distributes natural gas, that it's an ancillary facility within the meaning of the Chapter 91 regulations at 310 CMR 9.02 and 9.12 2D. By way of summary, everyone who is on this call, the parties and their respective counsel and witnesses know that this case has had a history in that my colleague, presiding officer Jane Rothschild, ruled in favor of Algonquin several years ago, which the then commissioner adopted as a final decision. The Weymouth residents appealed to Superior Court. The Superior Court remanded the matter back to DEP to reassess whether or not the compressor station is an ancillary facility pursuant to 310 CMR 10.02 and 310 CMR 9.12 2D. The court did so based on its determination or view of what the word require in the regulations at issue means. And as a result of the court's ruling, the matter went back to presiding officer Rothschild, who, based on the court's definition, determined based on the evidence that was in the record at the time, that the compressor station was not an ancillary facility, pursuant to 310 CMR 9.02 and 9.12(2D, and recommended that the matter be remanded for further permit review by Mass DEP's Chapter 91 program. The then Commissioner Martin Suberg did just that. It went back to DEP's Chapter 91 program, in accordance with a schedule that former Commissioner Suberg established for the review on remand. It was a schedule where Algonquin presented additional data through the filing of testimony from two individuals, expert witnesses, which the petitioners, which DEP first reviewed, Mass DEP's Chapter 91 program first reviewed, and then made a determination that in accordance with the Superior Court's definition, the program determined again that the compressor station at issue is an ancillary facility in accordance with 310 CMR 9.02 and 9.12(2D. The Weymouth residents disagreed with that, and so we are here to resolve the Weymouth residents' disagreement that determination by Mass DEP's Chapter 91 program was correct. Have I accurately summarized the proceedings to date? We'll start with Mr. Hayden.
Yes, thank you, Mr. Chief Presiding Officer.
Okay, Mr. Cram.
Yes, Mr. Chief Presiding Officer, thank you.
Sure. Mr. Bragg.
Yes, that it describes our procedural history.
Sure. Thank you. And so what we're going to do today is we're going to hear from four expert witnesses, one from the petitioners, two from the applicant Algonquin Gas Transmission, and one from Mass DEP. And the witnesses have all pre-filed sworn testimony as to what their respective party's position is in the appeal. And so all the parties are aware of what each party's position is in the appeal. And this hearing is a cross-examination process pursuant to which opposing counsel will cross-examine a party's witness. And the cross-examination will be in accordance to time limits that I will announce shortly. And my hope is that we can complete this hearing today. I indicated yesterday to counsel for the parties and other individuals associated with the respective parties that I am amenable to go beyond 5 o'clock this evening. My schedule is quite flexible, that I have no problem going to 6 o'clock if that means we conclude the hearing today. But I am aware and sensitive that other individuals who are part of this process might not have that flexibility. Because as I explained yesterday, if at the end of if at 5 o'clock, we are all of the opinion that it'll probably take another hour or so to complete the hearing, I would rather complete it today as opposed to bringing everybody back tomorrow morning for that. Do counsel for the party still feel, you all seemed amenable to go beyond 5 o'clock yesterday? Do you still feel that way? Mr. Hayden, we'll start with you.
Yes, thank you. From the petitioners, that's acceptable.
Mr. Cram?
Yes, the applicant has some flexibility as well. Thank you.
Okay. Mr. Bragg?
Yes, the department and its witness do have that flexibility.
Sure. Now, the way I mentioned about time limits for cross-examination. I have done this during my entire time as chief presiding officer. This isn't something that I'm doing especially for this case. Imposing time limits on the cross-examination of witnesses has been very effective in that it causes the parties to focus on those points that counsel want to make. And, assuming we began the cross-examination of the witnesses at 10 o'clock, and we 10 to 5 is 7 hours. And so you take 1 hour out for lunch, you're down to 6. And then you take another out for, I'm suggesting this, not saying it's going to happen, but 4 15-minute breaks, you're down to 5 hours. And I think an hour for each witness where, starting with the petitioner's expert witness, Dr. Ron Sahu, there would be 20 minutes of cross-examination by Algonquin's counsel, 20 minutes of cross-examination by Mass DEP's counsel, and 20 minutes for redirect examination by the petitioner's counsel. For the record, redirect examination is not allowed as of right. However, in every hearing I've done, I have allowed it so that matters that were raised on cross-examination can be clarified or further explained. Now, I've used Dr. Sahu as an example of what I mean by a time limit. And what I would do, let's say Algonquin's counsel has not completed or has reached the 20-minute mark. What I will do is what I've done in other cases. I will turn to DEP's counsel and ask whether or not they will yield their time, to the applicant. And if so, applicant's counsel will continue with the cross-examination, and it will conclude though after a total of 40 minutes of cross-examination, and then the petitioner's counsel will get to do redirect. If petitioner's counsel chooses, doesn't have to, but I mentioned that. Now, before we get started, just wanted to state for the record a stipulation that all the parties, counsel for all the parties reached last week regarding the testimony that was filed by 9 Weymouth residents. All counsel agreed that it would be prudent to simply acknowledge and admit all the testimony in the record as having been properly filed, because counsel for Mass DEP and Algonquin had no plans to cross-examine any of the 9 witnesses. And given that fact, it would not have been really a efficient use of time to have every single resident appear and be sworn in and to confirm testimony upon which neither Mass DEP nor Algonquin were going to cross-examine. So everyone agreed that the testimony of those 9 individuals would be admitted in the record, and I will consider it with all the other testimony that has been filed and made in pre-filed testimony, and that I will hear today on cross-examination. Counsel for the parties, have I accurately reported the stipulation? We'll start with Mr. Hayden for the petitioners.
Yes, thank you, Mr. Chief Presiding Officer.
Mr. Cram for the applicant.
Yes, thank you.
Mr. Bragg for Mass DEP.
Yes, that is accurate. Thank you, Mr. Presiding Officer.
So unless there are any other housekeeping procedural matters, I'd like to get started with the cross-examination of all the witnesses. Anything do you want to discuss with me now?
Just
Yeah.
one question for the petitioners,
Yes.
Mr. Chief Presiding Officer, concerning
Yes.
the time limits.
Yes,
I don't expect any issue with regard to my cross-examination of Mr. Durain and Mr. Paquette.
Yeah.
With regard to Ms. Hops, there are two issues. One, the department's written determination, and then separately, the question of environmental justice review. I
yeah,
do not have that line of inquiry for the applicant's witnesses, but as a result of additional cross-examination on the subject of environmental justice, I do expect my cross-exam of Ms. Hops to potentially be twice as long as my cross-exam of the applicant's witnesses. So to the extent that I can allocate my allotted time more heavily towards Ms. Hops, that would be my request for that reason.
I'll hear from opposing counsel, and then I'll tell you what I think. Mr. Graham, any objection to that?
I think my response is that we are also concerned about the 20-minute limitation. And in particular, I think it's going to take some time this morning getting used to how the exhibits and documents will work in the electronic process, which, although I've done something similar in this instance, the exact way we're doing it is new to me. So we're going to have to work through that, and whatever flexibility you can provide us would be appreciated.
I certainly on that end, so long as no one has any issues, I mean, I ultimately will decide, but so long as no one has any issues, I'm all for flexibility. As I indicated initially, time limits are a good starting point to let everyone know that there's a beginning and an end, and so things don't, drift off. But thank you. Mr. Bragg, your viewpoint, your opinion on Mr. Hayden's comment?
I suppose we'll have to see how it goes in terms of having that flexibility. I would hope that kind of given the rationale for the time limits to keep us on track, that we won't go too far afield and go into topics that are beyond the scope of Ms. Hopp's direct testimony.
Yeah, I thank you, Mr. Bragg. From what I understood, Mr. Hayden's to say that, and Mr. Hayden, I don't want to put any words in your mouth. So after I, speak, you certainly can confirm or correct me if I didn't get it right. But as I understood, Mr. Hayden, is that he wasn't going to take the same amount of time cross-examining each of the applicant's witnesses. And whatever time he had left over that he would have used, that he would apply it to cross-examining Ms. Hops if necessary. Am I right, Mr. Hayden?
Yes, thank you, Mr. Chief Presiding Officer.
And so I think with that flexibility, I think that keeps within the spirit of keeping things moving, because it's working within the parameters of the time frames. And I want to repeat again, flexibility is fine with me, so long as counsel are fine with it and are sticking to cross-examination of topics that were raised in direct pre-filed testimony, then we're good. And one of the very good things about this hearing is we have experienced counsel who have done trials and hearings before, so they know the process and moving it along. So is that fine? Have we covered all the housekeeping matters before we begin?
Yes, from the
The app-
petitioners.
Yep.
The applicant has one more,
Yes.
Mr. Jurland,
Yeah.
and I just want to note for the record that we did receive a communication from the Office of Appeals and Dispute Resolution yesterday afternoon,
Yeah.
indicating that it had not located copies of the pre-filed testimony that the applicant filed in October of 2022,
Yeah.
which included both the written direct testimony of Michael Durain and of Richard Paquette.
Yeah.
And I just wanted to confirm that you have received both of those and had a fair opportunity to review them in advance of their cross-examination today.
Sounds like you're cross-examining me, Mr. Cram, and being cracking a joke there. All I can say is this: is that the appeals office received those materials for the first time yesterday. I read all the pre-filed testimony. I began reading the exhibit attached to Mr. Paquette's pre-filed direct testimony. So I am certainly familiar with all the pre-filed testimony. The Exhibit 1 to Mr. Paquette's testimony is quite long, and I began it. But that is an exhibit like all other exhibits that I will review after the hearing and in conjunction with the closing briefs that the parties file after the transcript of the hearing is filed. And so I am more than confident that as a result of the review that I'm going to conduct, that that's fine. And that's why I said in my email of last evening, we'll proceed with the hearing today. And these hearings have been, for all presiding officers, including me, a way to educate, the presiding officer on the appeal. Presiding officers going into a hearing certainly have an understanding based on the filings made by the parties in the appeal. But there are things that could come up on cross-examination that neither the presiding officer and or the parties anticipated. The best example I can give you was I had a wetlands permit appeal adjudicatory hearing 11 years ago, and the petitioner basically destroyed his case on cross-examination when it was revealed he did not own the property that he claimed to own. And so the appeal, after pre-filed testimony and a lengthy hearing that took most of the day, you can all figure out where that appeal went. So, but thank you for your inquiry, Mr. Cram. I hope that satisfies you on that. So
Thank you.
Yeah, sure. And before I begin, I want to thank my colleague, presiding officer Jane Rothschild, who officially retired last year, but who I persuaded to come out of retirement to continue to provide excellent work for us in the appeals office. She has done tremendous work for us and is one of the best professionals I've ever worked with. That being said, I think we have covered the stipulation regarding the affidavits and pre-filed testimony of the 9 Weymouth residents. So to repeat, those affidavits, pre-filed testimony of 9 Weymouth residents, are hereby included in the record of this hearing as having been properly filed, with all the affidavits / pre-filed testimony having been submitted under the pains and penalties of perjury. Is that stipulation satisfactory to counsel for all the parties? Mr. Hayden, we'll start with you.
Yes, on behalf of the petitioners, thank you.
Mr. Cram, for the applicant?
Yes, thank you.
Sure. Mr. Bragg?
Yes.
Okay. So with that having been done, and we are running on schedule, we will begin with the cross-examination of the petitioner's expert, Dr. Ram Sahu. Mr. Sahu, I can see you're on our Zoom hearing. Welcome. Excuse me, I apologize. Dr. Sahu, do you promise to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Mr. Cram, excuse me, Mr. Hayden, if you can ask Dr. Sahu the customary questions that are asked of a witness who has filed pre-filed testimony regarding adoption of the testimony. If you could do that, please.
Yeah, yes, absolutely. And customarily, I also ask for the witness's professional background without getting into any substantive matters, if that's permissible.
You can, as long as it's brief, but I'm also going to give leeway to Algonquin's 2 witnesses. If Mr. Cram and his co-counsel believe that that's what they want to do. And likewise, Mr. Bragg, when it's Ms. Hops's turn to be cross-examined, if you feel that there should be a brief recitation of her background, that is acceptable to me. So is that understood by everyone?
Yes, thank you.
Yes.
Okay, Mr. Cram,
That's fine.
Mr. Bragg?
Yes.
Okay, Mr. Hayden, proceed.
Thank you. Good morning, Dr. Sahu.
Good morning.
Would you please describe for everyone your professional background?
Sure. I am a engineer. I got my bachelor's in mechanical engineering from the Indian Institute of Technology many years ago. I came to the United States in 1983 to go to graduate school. Got my master's and PhD at the California Institute of Technology, Caltech, not too far from where I live. And since that time, I've worked for the first 12 years. I worked for various design and engineering companies, including a very large company called Parsons. I left in the year 2000, and for the last 23 years, I've been a solo practitioner and consulting on a variety of matters, environmental related, air, water, waste, with clients that include the Department of Justice and EPA, various states, almost all the major national non-governmental organizations or environmental organizations, community groups, and several industrial clients and trade groups and trade associations.
Thank you, Dr. Sahu. Did you have an opportunity to prepare pre-filed direct testimony in connection with this proceeding?
I did.
Okay, I've placed a copy of that pre-filed testimony into the marked exhibit folder. If you have access to that or to a paper copy in front of you.
I see the marked exhibits list. I don't see mine. I see 5 documents there, but again, as was mentioned, maybe I'm not doing something exactly right. What I see right now are 5 other documents, but I don't see my pre-file on that list.
That's okay. I see what's happened. Are you seeing 2 folders, Dr. Sahu? One for hearing day 1, one for hearing day 2?
I am not. I'm seeing marked exhibits with just Ms. Hopps's 2 files, Mr. Duran's, and 2 from Mr. Paquette.
No worries. Just give me one moment. I'll correct this.
I believe it's under day 2. It's in the marked exhibit folder, but it's for, there were 2 different folders for 2 different days.
Thank you, Mr. Bragg. I'll upload it to day 1 right now so the witness has it.
Let me know if I need to refresh or something, or if it just automatically pops up once it's uploaded.
Okay. It should be there as indicated on my screen, so maybe double check.
Yeah, I do see it now. Yes, that worked.
Okay, so Dr. Sahu, did you prepare this pre-filed direct testimony yourself?
I did.
Did you prepare it under the pains and penalties of perjury?
I did.
Have you had a chance to review your pre-filed direct testimony in connection with preparing for today's hearing?
I briefly looked at it yesterday and the day before.
Okay. Do you adopt your pre-filed testimony for purposes of introducing your sworn testimony in connection with this proceeding?
I do.
Chief Presiding Officer, those are the preliminary questions I have for this witness, and the witness is now available for cross-examination.
Thank you. And as a result of Dr. Sahu officially adopting his pre-filed testimony, he is now available for cross-examination by Algonquin's and Master EP's respective counsel. As per the custom, only one attorney for each side gets to cross-examine the witness. There won't be any double teaming, in other words. And so, Mr. Cram, why don't we start with you as the attorney for Algonquin to begin with the cross-examination of Dr. Sahu. You have 20 minutes. At the 20-minute mark, I will check with Mr. Bragg to see if he will yield DEP's time. But why don't we begin now?
Good morning, Dr. Sahu.
Morning, Mr. Cram.
Nice to see you again.
Likewise.
When you signed your pre-filed direct testimony under the penalties of perjury, you understood that it should be accurate, correct?
That was the objective, and that's what I've aimed to do.
Did you also feel that it should completely state your opinions?
Yes, that was at least that was the aim and objective. Yes, Mr. Cram.
And you chose the words that you used carefully, correct?
Yes,
And you reviewed it before you signed it, correct?
yes,
Your report identifies a number of matters in which you have provided expert reports, affidavits, and testimony. I think there are 273 of them. Is that right?
I haven't counted them, but it's over many years. I'll take your word for it.
Okay. Are you familiar with the Massachusetts Public Waterfront Act, known as Chapter 91?
I have looked at it sometime past. I've been involved in this proceeding for some time, but not in preparation. The last day or two, I did not look at the regulations in preparation for
Okay.
this, but I looked at it, several months ago.
And I was actually referring to a statute that is Chapter 91 of the Mass General Laws. Are you familiar with that?
Statute and regulations, both. I was using the term broadly, but I have not looked at it to refresh my memory for this proceeding, but I did that 5 or 6 months ago.
Okay, and so you'll understand if I refer to Chapter 91 as that'll be referring to the statute.
Yes,
Is that fair? And
Yes.
if I refer to the regulations, or if I refer to 310 CMR 9.00 as the regulations, you'll know what I mean?
yes.
Okay. Do any of the matters that are listed on your resume and in your pre-filed testimony concern Chapter 91 or the application of the regulations?
They do not. My understanding is this is a matter for which Mass DEP is dealing with essentially for the first time as well, but they do not.
Okay. And so when was the last time that you provided an opinion with respect to the application of Chapter 91 or the regulations?
I have not. That's confirmed by the previous answer. This is the first matter in which I looked at the technical aspects of what the appeal was about, and I'm providing my technical opinions as a result.
Okay, so where your testimony includes a description of your teaching activities and of your presenting activities, you also haven't presented on the statute, on Chapter 91 or the regulations, correct?
That is correct.
Did you write your report? Or
Yes.
your pre-filed testimony? Sorry.
Yes. I drafted my report. I'm sure counsel looked at it, but I wrote my report.
Have you ever visited the site of the compressor station in Weymouth?
Not as part of my work here. I have a sister who lived in Quincy for a long time, and I'm sure I've gone by that area, but it was not in connection with the matter, specifically to visit the site.
In paragraph 5 of your testimony, and are you able to see that somewhere?
I do have mine also open. If it's the same for you, I can do it either way. Tell me if it's okay. I can look at the version on my computer.
If it's a clean copy, that's fine with me.
Oh yeah, it's the same copy. Yes.
Okay. So, in paragraph 5, you state that based on the testimony provided in my analysis, it's my opinion that EMD is backed for the current application of the AGT Weymouth compressor station. I focus my testimony on NOx emissions since that is the major pollutant whose emissions are at issue. Did I get that right?
Yes.
Right. And an EMD is an electric motor drive.
Yes.
And backed is an emissions regulatory term that stands for the best available control technology.
Yes.
You testified in proceedings before Mass DEP related to the non-major air quality plan approval that Mass DEP issued for the compressor station in Weymouth, correct?
Correct.
And your opinion there was that EMD was backed for the Weymouth compressor station, correct?
Yes.
And paragraph 5 of your testimony submitted in this proceeding is verbatim from, that is, it says the exact same thing as testimony that you submitted in the air quality plan approval proceedings. Is that correct?
That has been my opinion. That still is my opinion. Yes.
And you're aware that Mass DEP found that an EMD is not backed for the compressor station, correct?
Yes,
Okay. And you're also aware that Mass DEP's decision was appealed to the First Circuit Court of Appeals, which affirmed the DEP's decision that an EMD does not represent backed, correct?
I haven't traced all of that, but I'll take your word for it. Sure.
Okay, so that's not something that you're aware of before today?
Well, it's not, I didn't say that. I said, I'll take your word for it. I have not looked at and traced all of what happened after the DEP's determinations.
Okay. Did you know that the First Circuit Court of Appeals affirmed the department's decision?
If I did, I did not remember that specifically. I'm just giving you my technical opinion here, just for the record, because I didn't know the entire scope of this proceeding. So I thought that's an opinion I still hold. So I left it there for full disclosure.
Okay. In paragraph 6 of your testimony, you say that the purpose of the AGT compressor station is to compress pipeline natural gas in order to boost its pressure so that it can travel another 40 to 50 miles along the pipeline, overcoming pipeline friction. You see that?
Yes, I do see that.
And you say that is the only purpose of the AGT compressor station, right?
That's typically, in my experience, what compressor stations are for, is to enable the passage of the fluid, in this case, natural gas or gas, or to overcome friction in the line for the next until it gets to be compressed again, and so on, wherever it needs to go.
So this is a general statement in paragraph 6 that concerns compressor stations and not necessarily the compressor station in Weymouth specifically?
Well, my understanding is the Weymouth AGT compressor station has the same functionality, mainly to boost the pressure to enable the gas to flow further along the line, down, sort of downstream.
Okay. And in paragraph 6, when you say so that the gas can travel another 40 to 50 miles along the pipeline, where you say 40 to 50 miles along the pipeline, what pipeline are you referring to?
That is generic. So in other words, I was trying to give the impression and context that compressor stations are typically designed not to send the gas another half a mile or 500 miles, but it's in that order of magnitude. It could be 10 miles, 20, 30, but in the order of magnitude of about 40 to 50. I picked that for context to make it clear to folks that it is not a short distance like a few miles, and nor is it an extraordinarily long distance like hundreds of miles.
Okay, so when you say that that was the only purpose of the AGT compressor station, you weren't actually referring to a specific purpose of the AGT compressor station, correct?
Right. I mean, I'm saying the AGT compressor station is a compressor station, and its purpose is to transmit the gas further downstream by boosting its pressure. And it would generally, as compressor stations do for gas transmission, transmit that gas several tens of miles. You can interpret that paragraph that way.
Paragraph 8 of your testimony quotes text from Algonquin's Chapter 91 Waterways License application. Is that correct?
Yes, a very large quote. That's correct.
Okay. And you defined in the very beginning of it the application to mean Algonquin's Chapter 91 Waterways application, correct?
That's what I did, yes.
And then in paragraph 9 of your report,
Yes.
it says that it quotes section 10.8.23 of the application. You see that?
10.8.2 is what I have, yes. And that,
sorry, that's right, 10.8.2.
yes, and that's another long block quote, again, for context.
And do you know, is that from the application or is that from one of the attachments to the application?
That's a good question. I don't know sitting here right now, but I tried to be as accurate as I could, but it's certainly the quote from the application or the applicant.
Okay. I am just going to ask you to take a quick look at the application.
Oh, okay. Tell me if I'm going to the other documents. Which document am I looking at, or you're asking me to look at, Mr. Cram?
The application should be there and should be the new document in that same folder that you were looking at before.
Just give it a second. It hasn't popped up quite yet. So I still see the same 6 files. So maybe
If you maybe click the marked exhibit folder again to refresh it.
I just did that. Thank you so much. Yes, it did come in. Is that exhibit 0005, Mr. Cram?
Yes, thank
Do you
you.
want me to open it up? I just am opening it up. Give me a second.
Yes, please.
No problem. It's doing something. It's must be a big file, so it's probably taking it. It's saying generating file preview may take a while, just so everybody knows the message I'm seeing.
Okay. Well, do you know if the reference to 10.8.2 is actually to resource report 10, which was an exhibit to Algonquin's application?
It may well be. I'm not going to contest you, but I tried to, if I've misrepresented, it is instead of the main application, one of the attachments. We can confirm that, but it is from the applicant. That was the idea, that there was part of the application.
Okay.
This is still doing its thing, Mr. Cram. Tell me what I need to do.
I think we're just going to have to let it go for a second, and we'll move on. We can come back to that point if we need to.
Okay.
But
Sure.
do you know what resource report 10 is?
It was part of the application. It provided discussions that supported the application, is all I can tell you right now. I don't remember from memory here everything that resource report 10 included. Perhaps when it opens up, it can refresh my memory. It's still hung up there.
One of my colleagues might be able to share screen here, and we can do it that way if that's helpful.
Sure, whatever
No,
you
whatever
wish.
will expedite this, because I certainly would like the cross-examination be, substantive regarding testimony, regarding instead of being bogged down on a particular exhibit. So to the extent that that can be shared, that would be great. Thanks.
Yeah, that's probably a good idea. I'm getting another message for the record saying file preview still in progress. You can stay on this page and keep trying manually, or exit the link and return at a later time and reload. So that looks like.
Okay, well, it looks like we've been able to share it on the screen.
I
You
see.
recognize this as the
Yes.
application? Okay.
Yes.
If we scroll to the table of contents, you can see it doesn't have a section 10.
Okay.
But if we go down to the exhibits, you can see it does include resource report 10.
Yes.
You can go to it. Is that attached to this
The
document?
appendix A. Yeah.
We'll put resource report 10 up. And we'll keep going while we do that. So in paragraph 10 of your testimony, you include a figure that you said came from 10.8.1.
Right.
You see that?
Yes.
And so that came from resource report 10. Is that right?
Yes, I believe so.
Okay. And do you know whether the figure that you have in your testimony is the entire figure that was in resource report 10 or just a portion of it?
It was an excerpt that I do remember, because my recollection is there were many figures, and this was an excerpt of a figure showing just the different alternatives. So it was a portion of the figure, is my recollection, Mr. Cram.
Okay, so one of the things that was omitted in that process is the key that would explain what the various lines on the figure represent.
Yes, there were colored keys showing the different segments, I8, I9, that type of stuff. Yes. Suction discharge lines, and those type of things.
And the legends said that each of the red square was an alternative compressor station location, correct?
Right.
And the red dashed lines represented both suction and discharge pipes for the alternative compressor station sites, correct?
Correct.
And in paragraph 10 of your testimony, you say that more than half of the alternate site locations for compressor stations submitted by Algonquin are not even connected to the hub line, but rather tie into different pipelines located south of the hub line, correct?
Yes, that is what I could take from the figure. I mean, as this figure, you can see the hub line is the orange one, I believe, that is heading off to the top, to the north of the page, and then I9 and I8 are shown, and I3 is shown in 3 different colors, and then the red dotted line or the red dashed lines are connected to the at least for some of the alternatives are connected to these other yellow and other lines, as opposed to the hub line, which would be the solid orange line heading north from the proposed Weymouth station at that time.
Okay. And do you know, looking at this today, if all of the alternate locations have discharge pipes reflected by dotted red lines that go all the way to the hub line in Weymouth?
I have not looked at that specific issue since. This was what was, I looked at it because these alternates were being compared to the Weymouth compressor station by the DEP and found to be wanting. So I just wanted to see where they were located and how they connected. And I've given you my understanding based on this figure and the color coding there as to where these alternates would have connected. And I didn't see, because most of them are to the south, that many of them don't appear to connect directly, at least on the resolution of this figure, to the hub line. That was my understanding.
Did you read the narrative portion of Resource Report 10?
I can't remember if I read all of it or portions of it sitting here right now. I certainly have not looked at it very recently.
You did quote it in your testimony, correct?
Yes. So I did look at, but all of it or portions of it, I don't recall right now.
Okay. Could you turn to, can we look at, I guess, page 1034 and section 10.841 of Resource Report 10?
Okay, I thank you for blowing that up a little bit. It's a little easier to read, but tell me what you want me to look at.
Can you look at the last sentence in the first paragraph under 10.8.4.1 and read that?
Give me 1 second to just look at the paragraph briefly, and I will certainly do that, Mr. Cram.
Sure.
A 30-inch diameter discharge pipeline, that's what I'm reading here that you asked me to read. A 30-inch diameter discharge pipeline would be required to connect each alternative site to the I-10 system, along with a 30-inch diameter suction pipeline connecting each alternative station site with the Algonquin mainline pipeline system. That's what it says.
Thank you. Do you agree with that statement?
Yes, my understanding is the entire pipeline has a system connecting different legs or different sections of it. And obviously, the whole point of a compressor station is it has to take a suction line from where you want to boost the pressure and discharge it to a different portion of that pipeline system. And so I understand that that's what the whole point of a compressor station would be.
And in that sentence where it refers to the I-10 system, that's the hub line, correct?
The I-10 is the hub line. the I-10 system may include more than just the hub line. The word is system. The entire pipeline functions as a system. Gas flows seamlessly from 3 to 8 to 9 to 10, and all of them require, pressures to be maintained so the gas can flow. That's my understanding of how that system works, Mr. Cram.
Okay, and so you
Mr. Cram,
understand,
Mr. Cram, excuse me, before you ask your next question, I just wanted to note for the record that we're at the 20-minute mark. Mr. Bragg, do you yield DEP's cross-examination time to Mr. Cram?
I do, Mr. Giannino.
Okay, so I will let Mr. Cram continue with the cross-examination. I will not stop him during that 20-minute period unless you tell me, Mr. Bragg, during that period that there might be a question that you might want, cross-exam question that you might want to ask Dr. Sahu. Is that understood, everyone? Okay.
Yes, thank you.
Yep. Proceed, Mr. Cram.
okay, so Dr. Sahu, you agree that with respect to each of the alternative compressor station sites considered, each of them would be required to connect to the hub line system with a 30-inch diameter discharge pipe, correct?
Well, that's what I'm reading here. As an engineer, I don't agree that that would be required. You can boost the pressure at any section of a system of pipelines and allow the gas to be transmitted. I'm reading what you asked me to read, and that's what it says. As an engineer, I disagree that that is the only way in which you can accomplish the goal, which is to move gas along that pipeline system consisting of multiple legs.
Okay, and does your testimony include a hydraulic analysis of the Algonquin pipeline system?
My testimony does not include a hydraulic analysis. That was not my charge. I did not see the referenced hydraulic analysis by Algonquin with various alternates of how to put compressor stations in different places to get the required system moving. But I'm familiar with hydraulic analysis, but it was not my charge to prepare one. I was not asked to do one.
Okay, and so you haven't analyzed the maximum allowable operating pressure with respect to all of the pipelines in Algonquin system, correct?
I have not, but I've seen statements and numbers that as the MAOP values for different segments and legs. I'm aware of what has been mentioned by others.
Yeah, and you yourself did not analyze the operating pressure of the various pipelines in the Algonquin system, correct?
If you could clarify what you mean by I did not analyze, well, what do you mean by that?
Your testimony does not include any technical analysis of the operating pressures of the various sections of the Algonquin pipeline system, correct?
No, because I wouldn't have that type of information, but I do note that I think that I've said again that others have mentioned different operating pressures or ranges of MAOPs for different segments. I'm aware of that.
Okay, let's just keep moving. In paragraph 14 of your testimony,
Sure.
when you're there,
I am there.
you state that figure 10.8.1 of the application clearly demonstrates that the alternate sites can be located both elsewhere from the hub line and outside of Chapter 91 waterways jurisdiction, right?
Yes.
Okay, and did you mean if you don't consider that's true, if you don't consider the suction and discharge pipes that would be associated with each of the alternatives?
Well, that for sure. That means the footprint of the compressor station itself could be away. That's number one. And number two, as I said before, even if you want to put suction and discharge lines, they don't necessarily have to connect to the hub line. That's my engineering opinion, because you could still boost the pressure in the system, let's say by having suction discharge half a mile or 3/4 of a mile, upstream on I-9 and boost the pressure and send it along. It's my understanding that gas was flowing from south to north, as I say in my testimony, even before the compressor station was in place. So you could, if the goal is to boost pressure, you could do it both by locating the compressor station itself away from the pipeline system, including the hub line, and boost pressure at a different leg. I also think as an engineering matter, you could put two compressor stations. You can accomplish the passage by putting a smaller one upstream. You can put something further down. You don't have to take all 40 miles in one go. You can take 20 miles if there's an environmentally sensitive area to be transmitted. There are many, many options to allowing the gas to be moved along by boosting its pressure to overcome pressure drops. That's what I'm saying.
And your testimony doesn't include any sort of technical analysis of what you're describing, correct?
My testimony includes the conceptual idea that you can accomplish gas movement in a pipeline by multiple ways, locating compressor stations, suction lines, discharge lines in that system. That is what it requires. The detailed engineering was not my charge. I was mentioning as an engineer with about 30 plus years of experience that that's eminently possible. And there are hundreds of compressor stations in the country that move gas around in a complex system of pipelines every day.
Okay. Paragraph 18 of your testimony.
18, let me just get there very quickly, Mr. Graham. Yes, I am there.
It says that the compressor station will compress and inject gas from the I-9 into the hub line I-10, right?
Well, I mean, the gas, if you want gas to flow from south to north, the gas is going to first go through I-9 and then go into I-10. That's what I was trying to convey.
Okay, so but that's correct, right?
In a southward flow, it would go that way, is my understanding. I mean, in a northward flow, rather, from the south to the north.
And in paragraph 20 of your testimony,
Okay.
you state that the Weymouth compressor station will compress an additional 80,000 decatherms per day of gas from the I-9 pipeline and inject it into the hub line, correct?
Again, that's my understanding is of what was intended to move in additional gas up north.
And with respect to the land-based alternatives that Algonquin considered, in each case, the compressor stations would take gas from the closest Algonquin mainline pipeline. You agree with that?
Well, you're talking about the alternatives we're looking at in that figure 10.8.1. Yes,
Yeah.
those were a selected subset for reasons that I fully don't, it's not fleshed out. I think they were done for a different purpose, for a different proceeding, but those alternatives are shown and we've discussed that. Yes, they're located where it was located for other reasons, and they were taking their suction from particular places in many portions of that system. And according to them, they were discharging it into the hub line. That is what was the vision for Algonquin.
Thank you.
There are many
That's
more
exactly-
options than that, is what I'm saying.
Okay. In paragraph 18 of your testimony, jumping back,
Okay.
you state that Mr. Powers' testimony from a prior phase of this proceeding explained that there are other available methods to ship gas from the south to the north through the hub line without the need for a compressor station. Do you see that?
I do see that at the end of that paragraph, and all of paragraph 19 continues further that gas has been flowing before the compressor station was in place. So both points.
And so you haven't done an analysis on your own to determine exactly what methods to ship gas from the south to the north from the hub line are available today, correct?
I have not done that myself because I relied on testimony provided by Algonquin, both, again, 18 and 19 in proceedings that preceded the installation of the compressor station, that gas was able to flow from south to north. Even though that was not the intended purpose of the hub line when it was first installed 20 years ago, setting that aside, when gas was supposed to flow from north to south, which was the intended purpose, setting aside that that's now been reversed, the purpose has been changed, that gas was able to flow as confirmed in 2018, long before, many years before the initiation of compression by the compressor station. That's my understanding.
Okay. And is it your understanding that gas flowed from the I-9 into the I-10 before the installation of the compressor station?
I can't tell you whether it flowed from I-9 to I-10 or in some other way, but gas was able to flow along the pipeline system, which is the whole purpose, to take it to the points north, as was the intention of reversing the flow.
Could we put up the plan of the system? Just like you take a quick look at the plan of the Algonquin system.
Are you going to share something, Mr. Crime?
Yes, we'll
Oh,
do
okay.
that.
Okay. I will look for that. Just for the record, the previous document has still not opened on Veritext, so I'm glad we went with Plan B here.
I'm glad we had a plan B.
Yes.
Which shows the whole Algonquin green pipeline. Yes. Thank you for your patience, everyone.
Okay. I see
You
a
recognize
figure.
what
I
this
see a
is?
figure. Yeah.
So just pull that down a little, Katie. Okay. Can you see, you described to us where the hub line is on this plan?
It's close to the northern part where you see Boston, of course. I mean, it would be in that part of the entire Atlantic Bridge project. Yeah.
Sort of to the right of Boston and headed north up into a Y.
Yeah. Why just before the Salem letters, at least, I think.
Okay. And can you move the arrow just a little over to that point? Yeah. Dr. Sahu, do you know what that is? The lateral that goes off into the ocean there?
I don't remember the name of it, the designation of it, if that's what you're asking. Sorry.
Do you recall substantively what it is?
It just shows that the gas could flow into that lateral and then go underneath the bay, I suppose, much farther north.
It's your opinion that the lateral that is headed off to the east on this plan connects to what?
No, I didn't know which direction it goes from there, but
I see.
Yeah.
Do you know if that's an LNG terminal?
I don't know that that's an LNG terminal, but I'll take your word for it if that's the terminus of that line there.
Okay. Do you
You're
know
talking about the one to the left or to the right? I'm sorry, I should just ask. Which part of the Y?
Right.
Were you... Oh, I
right
see.
right at the cursor.
Okay. I'm sorry. I was looking at the other one on to the left. No, I don't. If that's a terminus for LNG, that's fine.
Not something you know about.
Not something that I was particularly concerned about. The point I was making is whether the compressor station was necessary to move gas in that segment, in that part of the pipeline segment from south to north. And that question was answered for me multiple times, as I've quoted, that gas could flow from south to north in that portion where the compressor station is located without the compressor station. As to where it went from there, whether some of it went to an LNG terminal, some went to somebody's house to help them cook, I was not focused on that.
And do you know if Mr. Bocock in the testimony that you're referring to was describing gas that came in from the LNG terminal and moved from a south to north direction at that very end of the hub line?
I don't know if he did that or not, but the testimony is that in that section, gas could be shipped from south to north through that hub line.
Okay, so you really weren't concerned with the specifics of the actual Algonquin system at issue, were you?
Well, I was focused on the Algonquin system where the gas was flowing, or where the claim was made that you could not flow gas but for this compressor station.
In paragraph 30 of your testimony,
30, is that what you said? I just want to hear.
yes, please.
Oh, 30. Okay, let me just scroll over there. Yes, I am there.
You acknowledge that there may be environmental benefits to locating the compressor station as it currently exists, correct?
Yes, environmental benefits have not been fully assessed for any of the alternatives, much less the larger pool of alternatives. But sure, there could be environmental benefits and also detriments. I mean, in other words, the environmental analysis is more than just the benefits. I mean,
Okay.
the totality of environmental impacts has been just talked about without any analysis for a very limited set of alternatives, not covering the full range of alternatives that could accomplish the functionality intended by the compressor station is the point I'm making.
And you have not done any sort of technical analysis of the environmental benefits or impacts associated with locating the compressor station in its existing site, correct?
I was not charged with that. I was critiquing the analysis done by others, the support provided for those analyses. For example, the lack of recognition that this site where the compressor station is located has other higher and better uses, beneficial uses. So none of that was looked at that I was looking for in the record, other than claims and conclusionary claims made that of the 7 locations arbitrarily picked, this appeared to be the best location from minimizing environmental impacts. That's what I'm critiquing.
As part of the work that you've done outside of this case, have you ever prepared an alternatives analysis to analyze where it would be best to locate a natural gas facility from an environmental perspective?
Years ago, when I was with Parsons, they were in the energy business, and we looked at alternative sites. I can't remember if it was for compressor stations, for actual fields, certainly laterals, lines. A lot of that as part of environmental impact statements. I recall participating in those, but that was when I was with Parsons. Sure.
Okay, so you've done that before,
Yes,
but just not here.
I've not done that here. I would need access to a lot more information and interacting directly with Algonquin and so on. That was not my charge here.
Okay, in paragraph 28 of your testimony.
Let me just go right back. Yes, I'm there.
Thank you. You acknowledge that compressor stations have both suction and discharge pipelines, correct?
Yes, that's typically how they function, right?
And the suction pipeline takes gas in?
Suction pipeline takes gas into the compressor station. That's correct.
And the discharge pipeline sends compressed gas out, correct?
Right.
But then in paragraph 28, you say that compressor stations do not have to be located physically adjacent to either the suction or discharge pipelines.
Yeah, what I mean by that, let me see. In fact, there's a main line that you're trying to boost the pressure off. You need the little legs, the suction line, so to speak, is the leg of the, if you will, access to that main line where you want to draw the gas from. And the discharge is another short line that puts it back into the main line. So the suction and discharge legs probably would have been better. And then the line is the main line itself.
Okay, so it is not your opinion that compressor stations don't have to connect to suction and inlet pipelines, right?
I mean, the gas has to flow physically and it can't just go out in the air. The gas has to be directed from wherever it is you're trying to, boost the pressure from. Gas is losing pressure as due to friction. You decide you need to boost it. You have to draw that gas away from the main line. I call that the suction leg. Comes to a compressor or a station with compressors, gets boosted, goes back with another leg. That's the discharge leg, and joins back up with the line and continues in whichever direction. That's what I'm saying.
So just to adopt your terminology.
Mr. Cram, excuse me. I just wanted to let you know we're about 2 minutes away from concluding the 20 minutes that have been allotted to the Department for cross-examination. Just wanted to let you know.
I will wrap it up then on this question, I think. But just to adopt your terminology, Dr. Sahu, it's an engineering requirement that a compressor station connect to its suction legs and discharge legs, correct?
Yes, the gas has to be contained, is my opinion. Yes.
Okay, thank you for your time, Dr. Sutler.
Thank you, Mr. Cran.
I will accord Mr. Hayden as the petitioner's counsel 20 minutes of redirect examination questioning. As I indicated at the outset, redirect examination is not allowed as a right, but per the discretion of the presiding officer. I have always allowed redirect examination. And with that being said, Mr. Hayden, proceed. You have 20 minutes.
Thank you, Mr. Chief Presiding Officer. If I could just, we don't need to pause the proceeding. I just need 30 seconds to add an exhibit to the
Sure.
folder.
If you could do that, if you can do share screen, like Mr. Cram did, I think that was pretty helpful to all, including me.
Okay, understood.
Sure.
And I just want to clarify, this exhibit is part of the administrative record, has already been submitted.
These are. Okay. I've added 3 exhibits, Mr. Chief Presiding Officer, and I'll share my screen as well for this first exhibit. Dr. Sahu, are you seeing what is
Portions
page?
of day one testimony from August 1 of 2018, page 108.
Yes, okay. And I'll represent to you that this is the testimony from Mr. Bocock that was raised during the cross-examination. Could you take a moment and just read this page to yourself?
Sure. Yes, I have.
And was this testimony from Mr. Bocock the basis for your understanding that gas had flowed north through the I-10 pipeline prior to the construction of the Weymouth compressor station?
It was specifically, just to put a pointer on it. First, he confirms that the entire system is bidirectional. And he says that at the top, you can see that. Then he confirms that when asked, does gas flow from the I-10 north? And he says it has. And then he talks about the numbers further down. And that's what I remembered. And that's what I was relying on for paragraph 19.
And what is the significance of Mr. Bocock's testimony that the entire system is bidirectional as opposed to only the I-10?
Gas flows from segment to segment along the entire system. And that means gas could flow from south to north or from north to south along the entire route from all of the legs, and therefore through the section that is of relevance to this proceeding. And this was all done, of course, before the compressor station was in place.
I'm going to draw your attention to another.
If I can finish, so to connect the dots.
Absolutely.
Yeah, so what that means is it confirms that the compressor station was not necessary. You had the ability to do the flow of gas from south to north without the compressor station. As an engineering matter, you do not need, therefore, the compressor station to accomplish the purpose that is now, it is being said that it is essential or necessary to do that purpose. I'm sorry to complete that answer. Thank you.
No, thank you, Dr. Sahu. And to to ask the same question with the terminology applicable to this proceeding. Does the I-10 hub line require the compressor station to have an adjacent location to the hub line in order to ship gas from south to north?
It does not, in my opinion. As an engineering matter, it does not.
I'm going to draw your attention to another document. Are you seeing section 10.8.3 from Resource Report 10 Alternatives?
Yes, portions of that. Yeah, exactly.
Okay, and I'm sharing my screen. I've also added this to the shared exhibit folder. Do you see the bottom paragraph of this
Yes.
page?
Yes, let me just read it quickly here. Yes.
Let me know
Yes.
when you've had a chance to review it.
Yes, I do see that.
You were asked questions about the MAOP for the various segments of the Algonquin system. Does this paragraph confirm that the I-9 system has an MAOP potential of 1,250 PSIG?
Yes, that's what it says. The I-9 portion, correct.
And the I-9 system's MAOP can be increased to 1,250 PSIG, correct?
Yes, because it was limited by the I-8 preceding the I-9. And so it could be bumped up. And it was capable of handling 1,250.
Okay. And does that matter to your engineering analysis of whether or not there is a quote unquote bottleneck between the I-9 and I-10 pipelines?
It doesn't. It seems to me that the bottleneck is in the I-8, I-9 section, as described there. But the broader point, Mr. Hayden, I want to make is wherever there are bottlenecks, you can accomplish boosting pressure in multiple ways. And there's not just one way in which you can boost pressure, whether it's at the point of bottleneck or before the point of bottleneck, you have multiple engineering options. But that specific issue, you've confirmed my memory there about 1,250 being the MAOP for I-9 and something lower for I-8.
Okay. I'd like to turn your attention to another area of your cross-examination. Do you recall you were directed to paragraph 18 of your pre-filed testimony and asked about your reliance upon William Powers' testimony in the prior Chapter 91 Waterways proceeding?
Yes, I do.
All right. I'm going to show you 4 pages from the August 1, 2018 hearing transcript. I'll represent to you that this is William Powers' testimony. I'd like you to take a moment and review it, and then I'll have a question for you. And it's 4 pages, so please take your time. Let me know when you're ready for me to advance through each page.
Is there a way, Mr. Hayden, you can make it full screen, or for some reason it shows up? If you can't, that's fine. I'll just ask you to blow it up a little bit. That's all.
What I can offer you, Dr. Sahu, is in the Veritex exhibit folder.
Yeah, let me go there. Let me go there. And this is which document there in that folder?
So this is entitled P for page 66 to 69, William Powers testimony, or William Powers TX.
Yep, I got it. Hopefully that'll open much quicker. Let's see. I promise I won't take too long. No, it's still doing that whole circle thing. Why don't you show me that? I'll rely on the screen.
Okay.
Let me read that. I'll quickly glance at it. I'll tell you when I need to move to the next.
I can make it as large
okay.
as you need.
No. Just the one before was fine. Now it's cutting off on the side. Yeah, this is perfect. Yes.
So just let me know as you'd like me to proceed down.
I
so
will.
you can continue.
I will. Okay, let's keep going down. Okay, let's keep going down. Go to the next page. Yeah. Okay, let's keep going down. Okay, let's keep going down. Keep going down. All right, let's finish it off. I do recall this. So. Okay, further down. Excellent. Okay, thank you. That refreshes.
Okay. And is this the testimony you relied upon in reaching the conclusion set forth in paragraph 18 of your pre-filed direct testimony?
Yes, I did.
And does this testimony support your conclusion that gas can flow south to north through the I-10 pipeline without the need to add any compression?
Yes, it does. And it talks about why that is and why you don't need to be at MAOP, that gas flow to meet demand can be at lower pressures. For all those reasons, it confirms that you don't require the compressor station for that flow to meet customer demand from south to north.
And you agree with Mr. Powers' description as contained in this exhibit?
Yes, that seems reasonable as to his explanation for why gas could flow and meet customer demand, and you're not tied to meeting MAOP pressures or boosting to MAOP pressures.
And again, this is gas flowing from south to north, correct?
Yes,
And that's consistent with your understanding that gas has flowed from south to north through the I-10 pipeline prior to the construction of the Weymouth compressor station, correct?
that is correct.
And further supports your conclusion that the I-10 hub line does not require any compression or compressor station in an adjacent location in order to move gas from south to north, correct?
That is correct.
Mr. Chief Presiding Officer, I do not have any further redirect examination.
Thank you, Mr. Hayden. I was planning to proceed with the cross-examination of Algonquin's witnesses
Excuse
now.
me.
Yeah.
My apologies. I had one recross just on an issue that came up during the redirect. One question, really.
I will allow it, but I'll say that the department did yield its cross-examination time to Mr. Graham. I will allow it for flexibility, and to the extent Mr. Graham has one question, I'm limiting it to one question. And then Mr. Hayden, out of fairness, if based on what is discussed or testified to by Dr. Sahu, you have a follow-up, you will be allowed to do so. So, Mr. Bragg, go ahead.
Thank you. Good morning, Dr. Sahu. How are you?
Good morning, Mr. Bragg. I'm fine, thank you.
Mr. Hayden asked you if you felt the compressor station was required for the hub line. I just had one follow-up for that, a yes or no. Would you say that the compressor station is operationally related to the hub line?
I think the operations compressor station would be related to the system as a whole. That's the function of a compressor station would be to boost pressures along the system. The hub line is a portion of the system. So no, I would not agree that the compressor station is required or is related to the hub line. In other words, it is related to the system to boost pressure to keep gas flowing is my understanding.
Okay, my apologies. I guess I wasn't very clear in my question. What I really asked was, in its location, is the compressor station operationally related to the hub line?
You mean as constructed?
As constructed, as it exists.
My understanding is as constructed, the discharge size connects to the hub line. That's my understanding, as constructed. But the point is whether that's even necessary.
Okay. All right. Thank you. That's the only question I had.
Thank you, Mr. Bragg.
Mr. Bragg, Mr. Cram?
I have just about 3 questions. I will limit it to one of the exhibits that Mr. Hayden showed. So this was page 108 of Mr. Bocock's testimony that you looked at a minute ago, Dr. Sahu. Do you see that
Yes.
now?
I do see that testimony. Thank you, Mr. Cram.
Okay. And when he was talking in the first section about the entire system, do you see that the question that was asked is about the Maritimes system? Do you see that?
I do see that. Yes.
And do you know the I-10 is part of the Algonquin system and not the Maritime system? Is that correct?
My understanding is the Algonquin gas or the Atlantic Bridge pipeline takes gas into the Maritimes as well and into the maritime provinces of Canada. That's my understanding.
Yes, but the Maritime system is a different system than the Algonquin system. Is that correct?
Connected to, but different. Yes.
Yes. Okay. And then with respect to the next series of questions about gas flowing from the I-10 north to the Maritimes pipeline, that is a different question from whether gas has flowed from the I-9 into the I-10, isn't it?
Well, the question is, did the gas flow from the I-10 north? My understanding is you can't get gas into the I-10 without it going through I-9. I'm not aware of a path of gas to get into I-10 without going through I-9.
And that's because you didn't know about the offshore LNG terminal until the hearing today, correct?
Well, that's not, if I knew it or not, that I can't say, but he's being asked, can it go from I-10 north to Maritime pipeline? And he says it has. He doesn't talk about that gas coming from the LNG terminal.
He doesn't? Would you keep reading on this page and do you see where he's asked how much gas? And he explains that it depends on how much the ships vaporized it. Do you see that?
He does say that, yes. But he doesn't say that that's all of the gas that can go just from the ships.
So what ships was he talking about?
Objection. I believe we're now getting beyond the scope of the redirect and beyond the one question limit that was imposed on the recross.
Mr. Cram, I understand what you're getting at, but I did limit it to one question. I'll let you complete this line of questions so long as it's related to what was addressed on a redirect examination by Mr. Hayden and Dr. Sauber.
I thank you. I think it is directly related. And if we could just have an answer to that question, what ships was Mr. Bocock testifying about?
And this will be the final question. Thanks.
You have to ask Mr. Bopak is the answer. I could elaborate on that, but I don't believe that he was talking exclusively about that as the only source.
Thank you.
Yeah. All done, Mr. Cram?
Yes, thank you very much.
Sure. Mr. Hayden, do you want to follow up with any further redirect examination questions based on what Mr. Bragg and Mr. Cram asked Dr. Sahu?
Thank you for the opportunity, but I do not have any further questions for Dr. Sahu.
Thank you. Now, as I indicated earlier, I was planning to proceed with the petitioner's cross-examination of Algonquin's witnesses. I'm ready to do that unless folks want to take a 5 to 10 minute break. We have been pretty much going since 9:30. How do people feel about taking a 10-minute break?
The applicant would appreciate it.
Okay.
That's agreeable as well to the petitioners.
Mr. Bragg?
That sounds good to me as well.
All right, so it's 11:04 right now. Why don't we reconvene at 11:15? How about that? Sound good?
Can I ask, so that I'm ready to begin with the next witness, which of the two witnesses will be proffered first?
Mr. Cram, that's up to you as to which witness you're going to call.
It'll be Michael Durain.
Okay, thank you.
Thank you.
All right, so we will reconvene at 11:15. Thank you.
Thank you.
At 11:15. Thank you.
Thank you.
at 11:15. Thank you. Hey, it's 11:15. Is everybody back on?
We are just
Yep.
working out a technology issue. We'll be right there.
Okay, yeah.
Okay, I believe we are all set.
Sure. All set. Mr. Hayden, on your side.
Yes, thank you.
All right. We are now resuming after a short recess with the evidentiary adjudicatory hearing. The next phase of the hearing will be the cross-examination of Algonquin's two witnesses. The two witnesses are Richard Paquette and Michael Durain. And Algonquin's counsel has indicated that Mr. Durain will be the first person called. Mr. Cran, excuse me, before that, am I pronouncing your name correctly, Mr. Durain? Is it right?
That's correct.
Okay, Mr. Durain, do you promise to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Mr. Cran, you can ask the customary questions for the adoption of the previous pre-filed testimony that Mr. Durain filed. I will accord you the same courtesy that I accorded Mr. Hayden and Dr. Sahu, that if in the course of asking the questions, the customary questions, you would like Mr. Durain to briefly discuss his background, you may do so, but that's entirely up to you.
Okay, thank you. I'm having a problem with my camera at the moment, which I'm hoping will come back up in just a second. But if you can hear me fine, we can proceed if that's okay with everyone.
That is fine. And for those who are watching on Mass DEP's YouTube channel, Mr. Cram is having technical difficulties with his camera. He has not shut off his camera. As soon as that is fixed, he will be back on. But we are able to hear him, and so Mr. Cram, proceed.
Okay, and just, I think in a minute or two when I get back to it. Oh,
There you go. We see
okay.
you now.
Pretty good timing.
Yes. Mm-hmm.
The applicant calls Mr. Michael Durain, the
Yep.
next witness.
Yep. And I just sworn him in. Yeah.
Mr. Durain, please state your current and title and employer for the record.
I am a manager of marketing and business development for Algonquin under the Enbridge Corporation.
And could how long have you been with the company?
I've been with the company 44 years.
And can you give a general description of your responsibilities?
I am in charge of marketing and business development with the customers in the New England area.
And as part of your responsibilities, do you have to have an understanding of the Algonquin pipeline system?
Yes, I do.
Do you have a copy of your pre-filed direct testimony in front of you?
I do.
And did you sign that under the pains and penalties of perjury?
I did.
Do you adopt it today as your testimony in this proceeding?
I do.
Thank you.
All right. Mr. Duran is available now for cross-examination by the petitioner's counsel, Mr. Hayden. Mr. Hayden, you have 40 minutes to cross-examine Mr. Duran. The floor is yours.
Thank you, Mr. Chief Presiding Officer. Good morning, Mr. Duran.
Good morning.
Have you heard of an Enbridge or Algonquin project known as Project Maple?
I have.
What is it?
We are in development based on customers last winter having a difficulty meeting their demand. They have indicated in the spring and the summer that there may be a need for additional capacity on the Algonquin system. So with that, we went into the first phase of the project, and we are eliciting nominations through November 17th from any customer wishing to have additional capacity on Algonquin gas.
And does Project Maple involve adding any compression to the hub line?
It does not.
And does Project Maple involve expanding the Weymouth compressor station as it's currently constructed?
It does not.
In paragraph, do you have a copy of your pre-filed testimony in front of you?
I do.
I'd like to draw your attention to paragraph 16 and 17.
Yes.
And have you had an opportunity to review Michael Tyrell and Jose Bocock's testimony in this proceeding?
I have reviewed some of it.
I've put 3 different documents into the shared exhibit folder. You're welcome to pull them up, or if it's easier, I can share my screen.
Thank you, Mr. Hayden. What I was going to say, in keeping with the other witnesses, if we can do a share screen when we're talking about exhibits, that would be great. Thank you.
You're welcome. Are you seeing, this is page 113 of Mr. Bocock's testimony from August 1, 2018?
I see that.
Have you had an opportunity to review this page of Mr. Bocock's testimony before?
I don't recall.
All right, well, please take a moment and read it, and then I'll have a follow-up question for you.
Okay.
You understand that Mr. Bocock testified that the compressor station could be placed in his words, someplace else other than its current location, correct?
I see that.
Do you agree with that?
I agree with his previous comment that it is the optimal location.
Understood. My question was, do you agree that with Mr. Bocock's testimony that the compressor station could be placed someplace else?
I think it would bring on some environmental issues to place it anywhere else. I think the location where it is optimal for the I-9 and the I-10.
I understand your viewpoint, and I'm just asking if you agree with Mr. Bocock's testimony, yes or no. You either agree that you could put the compressor station someplace else, as Mr. Bocock testified, or you disagree. Which is it?
You can put it someplace else.
Okay. I'd like to show you an excerpt from Michael Tyrell's testimony. This is 2 pages, so I'll give you a moment to read both of them. It's page 175 and 176 from the August 1, 2018 hearing. Let me know when you've had a chance to read this page, and then I'll forward it to the next page as well.
Do you mind making it just a little bit bigger, please? Thank you.
Absolutely.
Okay. 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 Okay.
All right. And what is Michael Tyrell's relationship to Enbridge and Algonquin?
He was the consultant that worked on the application for the Atlanta Bridge.
Thank you. And he testified on August 1, 2018 that the alternative locations for the compressor station that were set forth in Resource Report 10 were all reasonable alternatives, correct?
You know, Mr. Hayden, this isn't really my area of expertise. I believe that the other Algonquin representative could speak better to this information.
Okay, so you, what's your title again?
Manager of Business Development and Marketing for Algonquin Gas.
Okay, so as manager of business development and marketing for Algonquin Gas, you don't know whether alternative locations set forth in Resource Report 10 were reasonable or not?
I didn't prepare this part of the testimony, no.
No, it's Michael Tyrell's testimony, but you know who he is, correct?
I do.
And you don't have any reason to believe that he would lie under oath during the August 1, 2018 proceeding, do you?
No.
And you agree that his position in relation to the Atlantic Bridge project gave him the foundation and knowledge necessary to answer questions about the alternative locations proposed for the compressor station, correct?
Correct.
And he testified on page 176 at line 6 in response to the question, is it your position that these alternatives considered by the company satisfied the reasonableness requirement? His answer was yes, correct?
Correct.
And am I understanding you correctly that you don't believe that you have the necessary education, training, or experience with Algonquin to answer that question yourself?
I believe Mr. Paquette is better versed in this area.
Understood. So I'll ask Mr. Paquette these same questions, but in terms of your testimony today as a witness, do you believe that you're competent to answer this question that Michael Tyrell answered in the affirmative?
I have an understanding of the alternative analysis, but I wasn't involved in the preparation.
Understood. And I'm not asking if you were. I'm just asking if you, given your role with the company, believe that you can answer the same question put to Mr. Tyrell, which was, is it your position that the alternatives considered by the company satisfied the reasonableness requirement?
And the answer is yes.
You agree with Mr. Tyrell?
I do.
Mr. Girlandino, for the reasons that I stated before we began our proceeding, my intention is to be judicious with my cross-examination of both Mr. Durain and Mr. Paquette. So with the expectation that I'll be afforded some additional leeway in my cross-examination of Ms. Hops. For that reason, I have no further questions.
According to my fancy timer, you had 32 minutes left, so put that in the bank.
Thank you.
Okay. All right. Is there any redirect examination questions by Algonquin's counsel?
I have one. The
Okay.
camera problem seems to have been contagious. We're trying to get Mr. Durain back. I can't see him at this moment, but is he back?
He is. He's going to use Michael's computer, and we're going to change the name in a moment.
We've had to give Mr. Durain Michael Molstad's computer, but can everyone see him? Just move the camera over a little bit. We can see you, Mr. Durain.
Yeah.
There we go.
I see him. Does everyone else see him?
I do.
Mr. Hayden, do you see him as well?
I do. Thank you.
Okay, Mr. Cram, you may proceed.
Mr. Durain, do you know if Algonquin considered the alternative locations reasonable from an environmental perspective?
They did not.
No further questions?
Yeah. Although this is, Mr. Durain is a, not a hostile witness to DEP, so saying cross-examination is a misnomer. However, Mr. Bragg, if you have a question for Mr. Durain based on what was addressed on cross-examination, you may, but with the caveat, like I just stated, he's not a hostile witness to Mass DEP. Okay.
I have no questions for Mr. Durain.
Okay, thank you. So we now can proceed. You may step down, Mr. Durain. Thank you very much for participating today. You may step down. And so the next witness for cross-examination is Mr. Richard Paquette. I'll allow a few minutes for the exchange or change of witnesses, and tell me when you're ready, Mr. Cram.
Thank you. Yep, we'll just need a few minutes.
Partner Ms. Hill is going to handle this witness, and we're just getting that started.
Thank you, Ms. Hill. Let me know when you're ready.
Well set.
Did I hear you
Right.
say you were all set, Ms. Hill?
I think we are. Can everyone see Mr. Paquette?
Yeah, I see him. So we can do a roll call. Mr. Bragg, can you see him?
I can.
Mr. Hayden, can you see Mr. Paquette?
Yes, thank you.
Okay, Ms. Hill, you can proceed. Actually, before you proceed, Mr. Paquette, do you promise to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Ms. Hill, I will allow you to proceed with the witness with the customary questions regarding the adoption of pre-trial testimony. But like with the other witnesses, I will accord you the courtesy of allowing a few background questions, allowing Mr. Paquette to answer some background questions about himself. So you may proceed.
Thank you. Good morning, Mr. Paquette. Could you state your full name for the record, please?
My name is Richard Paquette.
And where are you employed?
I'm employed at SWCA Environmental Consultants.
And have you recently changed positions?
Yes, I have.
What is your current title?
Principal Project Manager.
Did you provide pre-filed direct testimony on behalf of the applicant in connection with this proceeding?
I did.
Did you also prepare rebuttal testimony on behalf of the applicant in connection with this proceeding?
I did.
And do you have a copy of those documents in front of you today?
I do.
And did you sign both of those under the pains and penalties of perjury?
I did.
And do you adopt both of those documents as your testimony in this proceeding today?
I do.
That's all I have.
Mr. Paquette, then, his pre-filed testimony is part of the record. He's available for cross-examination by the petitioner's counsel, Mr. Hayden. Like with the previous witness, you have 40 minutes, Mr. Hayden, for cross-examination.
Thank you, Mr. Chief Presiding Officer. Good morning, Mr. Paquette.
Morning, Mr. Hayden.
Do you have a copy of your pre-filed direct testimony and rebuttal pre-filed testimony in front of you?
Yes. I do.
In your pre-filed direct testimony, paragraph 2, you mentioned that you were previously employed as a senior project manager at TRC Environmental Corporation.
That's correct.
When you were at TRC, did you know Matthew Beaton?
I knew of him, but I didn't know him personally.
And what did you know of Mr. Beaton?
That he joined TRC and he was the previous director at MEPA.
And for the record, what is that, the acronym that you just described?
It's the Massachusetts Environmental Policy Act program.
Do you know if he was the secretary of the Executive Office of Energy and Environmental Affairs?
I believe that's actually the correct title.
And how, in your role at TRC, did you become aware of former Secretary Beaton joining TRC?
That was quite a while ago. I think there was just a general release of it, company release of new hires.
Did you have an opportunity to work with Matthew Beaton at any point?
No,
Did you have any interaction with Mr. Beaton when he was secretary of the EEA?
no.
If I could turn your attention to paragraph 5 of your pre-filed testimony.
Yes,
In paragraph 5, you identify 3 criteria for the compressor station. Is that
that's
correct?
right. That's correct.
The first category, at least 10 acres for the construction workspace. That's nothing that's unique to the current north parcel where the compressor station is located, correct?
I don't understand. What do you mean it's nothing unique? What do you mean by that?
So the 10 acres necessary for the construction workspace could be somewhere else, somewhere other than the north parcel.
That's correct.
Same question for the second criteria, the ability to receive natural gas via suction pipeline connecting with one of Algonquin's existing mainline natural gas pipeline systems. That criteria is not unique to the north parcel or to the I-10 hub line, correct?
No, that's not correct. With the compressor station, the purpose of the Weymouth compressor station is to connect at the interconnection of the I-9 and the I-10 with the suction and discharge pipelines.
I'm asking about criteria number 2.
Yes, I'm reading that.
All right. This is your sworn testimony, right?
Yes,
Did you prepare this yourself?
I did.
Did you review it for accuracy before you signed it?
Yes, I did.
Criteria 2 does not use the I-10 hub line, does not use the I-9 line, and does not refer to the interface between the I-10 and I-9, correct?
As I read that, you're correct.
All right. So the words you chose when you signed this sworn testimony under oath were the ability to receive natural gas via suction pipeline connecting with one of Algonquin's existing mainline natural gas pipeline systems, correct?
Yes,
So now, having had a moment to think about that, do you agree that criteria number 2 is not unique to the I-10 hub line or the north parcel?
if I understand your question, yes, I mean, this is just a general description of the base requirements for a compressor station. So you need a suction pipeline connecting to a mainline gas system, number 2. Correct.
Well, this paragraph 5 and the 3 criteria you've identified are for you use the word the compressor station, correct? So that's the compressor station subject of this proceeding.
Can you restate that question again? I've lost it.
Absolutely. When I asked you if the second criteria was not unique to the hub line or the north parcel, your answer was yes, these are general criteria for compressor stations. So my follow-up question to that is, in paragraph 5, you've identified, Algonquin has identified 3 criteria for the word the precedes compressor station, meaning the compressor station at issue in this proceeding.
Oh, yeah, Algonquin, if you're talking about the first sentence there, Algonquin identified 3 criteria for the compressor station site. So those are the 3 criteria that were provided by Algonquin as part of the requirements: the 10 acres, the suction pipeline connection, and then the discharge connection with the compressed gas.
Right. And you've already agreed with me that the 10 acres could be located somewhere else along the Algonquin line, correct? It doesn't have to be the north parcel.
Well, the construction workspace, I guess the answer to that would be in part because wherever you're going to build a compressor station, you're going to need construction workspace at the compressor station to build it. You might be able to utilize a separate parcel like across the street for staging, things of that nature. But at the end of the day, where you construct a compressor station, you're going to need construction workspace at that compressor station site.
Understood. So, for example, you could have longer suction and discharge lines and locate the 10 acres for construction workplace somewhere other than the north parcel, correct?
That's correct. If you had long suction or discharge lines, you could have the compressor station at a location other than where it's at right now.
Okay. And same question for criteria number 2, the ability to receive natural gas via suction pipeline connecting with one of Algonquin's existing mainline natural gas pipeline systems. You could accomplish that somewhere other than the north parcel as well, correct?
Yes, that's correct.
And do you agree that with Dr. Sahu's testimony this morning that compressor stations are typically constructed to boost compression in 40 to 50 mile segments?
That's beyond my technical area of expertise in terms of that specification. So I'm not prepared to provide an answer for that.
Okay. In paragraph 12 of your pre-filed direct testimony, take a moment to get there. Let me know when you have it.
Yes, I'm there.
So you reach a conclusion about whether the compressor station can reasonably be located away from tidal or inland waters. How do you make that conclusion if you don't have the technical expertise to understand the length of gas that a compressor station typically moves up the pipeline?
In conducting our analysis, our scope was to evaluate the alternatives that were provided to us by Algonquin as part of the Resource Report 10. Those are well established and been studied before. So the focus of our analysis was comparing those alternate sites to the existing compressor station site. And in doing that analysis, I determined that all of the alternate sites had significantly more environmental impact when compared to the existing compressor station site at the North Weymouth parcel. And applying the DEP's requirements in terms of water dependency and basing that determination on a comprehensive analysis of alternatives and other information that could demonstrate that all measures have been taken to avoid or minimize impacts to the environment. The existing site is required.
Isn't the way to avoid and minimize impacts to the environment not to build the compressor station at all?
That's considered a no action alternative.
Yeah, so the no action alternative is the safest possible decision to be made for protection of the environment, correct?
Yes, if you did nothing and you didn't do the project, then it stands to reason that you would have no impact to the environment.
And did you evaluate in connection with your review the ability for the Algonquin gas system to ship gas from south to north through the I-10 pipeline without adding a compressor station on the north parcel at the current location?
As part of my review, we looked at the analysis of the existing site in comparison to the alternate sites, the 7 alternate sites that were identified and described in my testimony.
All right. Have you had a chance to review Michael Tyrrell's testimony from August 1 of 2018 during the prior administrative hearing in this matter?
I have not. I've reviewed his pre-filed testimony, but I did not review what you have up on the screen.
That's okay. It's 2 pages long. It's page 175 and 176 from August 1, 2018 transcript. I'll scroll down as you have an opportunity to read through this. So just let me know when you're ready for me to move the page down a little further.
Give me 1 second. Something just popped up on my screen here. Yes, back in action here. Okay. 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 Okay.
All right. Do you know who Michael Tyrrell is?
I do.
And who is he?
Michael Tyrrell was the project director for the Atlantic Bridge project for TRC.
Did you work at TRC at the same time as Michael Tyrrell?
I did.
You believe he knew what he was talking about?
Yes, I do believe he knew what he was talking about. Okay.
So on page 175 of Mr. Tyrrell's testimony, he was asked do you agree that reasonable alternatives to a proposed project must be included in the alternatives analysis contained in the environmental assessment? Do you see that question?
I do.
And his answer was yes.
Yes, I see that.
And do you believe he had the knowledge and expertise to be able to answer that question?
Yes.
On page 176, Mr. Tyrell was asked at line 6, is it your position that these alternatives considered by the company satisfied the reasonableness requirement? And I'll draw your attention to line 1. Well, let me back it up. I want you to be able to see everything that he's answering. So page 175, I apologize for that, Mr. Chief Presiding Officer, just so we have a clean question for the witness. I'm going to start my question over.
Yeah, no problem.
Mr. Paquette, on page 175, line 24, Mr. Tyrell was asked, in resource report 10, the company analyzed 7 alternatives, I believe. Is that correct? 7 alternative locations to site their compressor station. At page 176, Mr. Tyrell answered, that's correct. Some generated by us, others asked by us to review. And then in follow-up to that, at line 6, Mr. Tyrell was asked, is it your position that these alternatives considered by the company satisfied the reasonableness requirement? And his answer was yes. Is that correct?
Yes, as I read that.
And did Mr. Tyrell have the education, training, and technical expertise necessary to answer that question?
Yes.
And he was the project director for TRC for the Atlantic Bridge project?
Yes.
And looking again at the question and answer on page 175, beginning at line 13, he was asked that reasonable alternatives to a proposed project must be included in the alternatives analysis contained in the environmental assessment. Do you see that?
Yes.
Do you have an understanding as to what the environmental assessment is referring to?
Yes, I do.
What is the environmental assessment?
The environmental assessment is the document that the Federal Energy Regulatory Commission staff prepares under the National Environmental Policy Act and the Natural Gas Act when reviewing a gas pipeline project subject to FERC jurisdiction.
Okay. And why is it called an environmental assessment?
Because it assesses environmental resources.
So in submitting proposed alternatives to FERC for the environmental assessment, which assesses environmental resources, Mr. Tyrell confirmed under oath that the 7 alternative compressor station locations included in resource report 10 were reasonable alternatives and that they met the reasonableness requirement. Is that correct?
That's what Michael says in his testimony.
And you agree that he had the expertise and technical training to be able to answer those questions?
Yes.
All right. I'm going to show you another page from Mr. Tyrell's testimony. This is page 235 from the August 1, 2018 hearing. Let me know when you have a chance to review this page of Mr. Tyrell's testimony.
Okay.
I'm sorry, let me show you the bottom of the page. You done reading the rest of that page, Mr. Paquette?
Just getting there.
Okay, yeah, I don't mean to rush you. Take your time. So at page 235 of the August 1, 2018 hearing transcript, at line 12, Mr. Tyrell was asked, the hub line has been functioning just fine since it was built in 2002 or 2003, correct? And he answers correct?
He answers correct, yes.
And you agree with that, correct?
I have nothing to the contrary. I haven't been tracking whether it's functioning fine. As far as that goes, but
That's
but
fair.
as far-
You have nothing to contradict Mr. Tyrell's testimony on that point, do you?
That's right. No,
And he's asked at line 16 of page 235, the hub line doesn't need the Weymouth compressor station to function in its current state, correct? And Mr. Tyrell's answer is correct. Is that right?
that's correct. Yeah.
All right. And you agree that he had the technical experience, education, and training to answer that question as well, right?
Yes.
So I'd like to turn your attention back to paragraph 12 of your pre-filed direct testimony, please.
Yes.
So we've just reviewed Mr. Tyrell's testimony that the hub line was functioning fine since 2002 or 2003, does not need the Weymouth compressor station to function in its current state, and the 7 alternative locations submitted in Resource Report 10 were considered reasonable for purposes of the environmental assessment prepared by FERC. You agree with all that, right?
Under the testimony that Mike provided, yes, he had indicated that they were reasonable for the purposes of FERC's consideration of what is a reasonable alternative.
And specifically in connection with the environmental assessment, which you helped explain for us, is a document FERC prepares under the National Environmental Protection Act, which assesses environmental resources, correct?
Yes, that's correct.
We've also established that you don't have the technical expertise to understand the length of pipe that a compressor station moves gas along a system before another compressor station is necessary. Is that fair?
I would qualify that by saying I understand that compressor stations are spaced out along an interstate gas system, and that spacing is set by the pipeline operators based on hydraulic analyses and that type of. So if you're asking me, do I know that a station needs to be 50 feet away from another, 50 miles away from another one? I do not, because that is something that Algonquin or other pipeline operators need to determine based on hydraulic analysis.
That's fair. So you don't understand the spacing that's done by pipeline operators. Is that a fair characterization?
Well, no, that is not fair, because I do understand that there's a hydraulic analysis pipeline engineers conduct to determine the spacing. But I do understand the concept that spacing is required and needed as part of any operating system.
Sure. How many compressor stations are there along the Algonquin pipeline?
I don't know off the top of my head the specific number of them.
How about an order of magnitude?
I'd have to think about that for a second. If you really want to know, I can think.
Yeah, take your time. We're not in a hurry.
I want to say that there's probably, and again, it's approximate because I cannot tell you the exact number, but I'm gonna say 6 or 7, perhaps.
Okay. All right. And how about nationwide? Do you have any idea how many compressor stations there are?
I do.
Objection.
And the basis, excuse me, Mr. Hayden, I want to hear Ms. Hill's objection. The basis of your objection?
I don't believe Mr. Paquette has testified about the number of compressor stations that are nationwide. It's out of the scope of his pre-filed testimony.
I agree. Mr. Hayden, if you can rephrase your question.
Thank you, Mr. Chief Presiding Officer. I'll narrow the focus, Mr. Paquette, to the 6 or 7 compressor stations along the Algonquin pipeline. How many of those are located in tidal or inland waters?
To my knowledge, none of them are.
So what is the basis for your conclusion in paragraph 12 of your pre-filed direct testimony that the Weymouth compressor station cannot reasonably be located away from tidal or inland waters when all 7 of the proposed alternatives included in Resource Report 10 were described by Mr. Tyrell in his testimony to have been reasonable in connection with their submission to FERC in completing the environmental assessment?
So, in my opinion, from reading Mr. Tyrell's testimony that you put on the screen with regards to what was reasonable, I believe, FERC expects an applicant to evaluate alternatives that are reasonable in the sense that they're not like impossible. For example, like you're not going to put an alternative in there with a compressor station, in the middle of a lake or something like that, or in the ocean. They have to be in some level, feasible from a technical standpoint in order to evaluate that. So that's how I interpret that reasonable language that you showed me. The language that I have in my testimony at item number 12, and again, in my eyes, it's a different test of reasonable from the standpoint specifically of the waterways program, and how the department and the secretary have to evaluate whether an infrastructure crossing facility or an ancillary facility is considered water dependent. And in order to do that, it cannot reasonably be located away from tidal or inland waters based on a comprehensive alternatives analysis and other information taken into account to evaluate the avoidance and minimization of environmental impacts. When you look at the existing site in comparison to those alternate sites are not reasonable when compared to the existing site. So that's how I came to that conclusion.
All right, so I want to make sure I understand your testimony on behalf of the applicant. You're saying that the 7 alternate locations included in Resource Report 10 submitted to FERC for the purpose of completing an environmental assessment were all unreasonable locations and are all unfit to site the compressor station as the applicant believes is necessary to operate the hub line going forward.
Objection. I don't think that's what he testified to.
I'll allow it. Overrule. Answer the question, Mr. Paquette, if you can.
Can you restate that, Mr. Hayden?
I can. I showed you Mr. Tyrell's testimony where he agrees that all 7 alternate locations included in Resource Report 10 were reasonable when submitted to FERC for the purpose of completing an environmental assessment. You recall that?
Yes.
I believe you just testified, and correct me if I'm wrong, that it's your opinion that that's not the case, and that when the applicant submitted 7 alternate locations in Resource Report 10 to FERC, they were all unreasonable and all unfit to site a compressor station necessary to facilitate gas moving from south to north through the hub line.
No, that's not what I was saying. During the FERC process, as I mentioned, they expect the applicant to evaluate alternatives that have technical feasibility to them. And as part of that resource report 10, you conduct that evaluation to determine what is the best site from the standpoint of avoiding or minimizing environmental impacts. The resource report 10 document, and ultimately the EA as well, came to the conclusion that the Weymouth compressor station site is the best or most preferable site from that standpoint when you compare it to the alternate sites that were evaluated. And so from that, it's not the characterization that they were unreasonable, unfit. It's basically, it comes out after the alternative analysis is complete, when you have the results in front of you, after looking at all the information. And again, from my previous statement about number 12, that is taking into account the specific language in the waterways regulations that for water dependency for infrastructure crossing facilities and ancillary facilities, in making that determination of whether it cannot be reasonably located away from tidal or inland waters.
You agree when Mr. Tyrell was asked whether the 7 alternate locations were reasonable, he did not say, well, they're not reasonable, but they are all technically feasible. That seems to be the distinction you're drawing.
In my mind, yes. I mean, that's the again, reasonable from the standpoint of the FERC lens of what is reasonable, and that's based on my experience.
But he agreed with the term reasonable. He didn't qualify it to say technically feasible, correct?
That's correct.
And the reasonableness testimony that Mr. Tyrell gave was in connection with FERC's environmental assessment as it pertains to this facility, correct?
Yes.
And you've testified already today that although you understand sort of the concept behind spacing compressor stations along a pipeline, you don't have the technical expertise to understand the exact spacing between compressor stations and what the requirements are. That's something that you would defer to the pipeline operators to figure out, correct?
Yes, that's right.
All right. And there's 6 or 7 other compressor stations along the Algonquin pipeline, none of which are located in tidal or inland waters, correct?
To my knowledge, that's correct.
So is it fair to say that you're not necessarily the best person to reach a conclusion of whether this Weymouth compressor station can reasonably be located away from tidal or inland waters?
Objection.
And the basis of your objection, Ms. Hill?
I don't believe he's laid a foundation for that.
Mr. Hayden, can you rephrase the question or ask some preliminary questions so you can ask the question you want Mr. Paquette to answer?
Sure. And my intended foundation was the witness's testimony that he doesn't understand, the specifics behind a pipeline operator's calculation of how to space compressor stations, but I'll build that into the question so that it's more clear. Mr. Paquette, understanding that you do not have the technical expertise to determine the exact spacing in terms of miles between compressor stations on a pipeline such as the Algonquin pipeline, do you agree that someone else would be in a better position, having technical knowledge of where compressor stations must be located, to answer the question of whether the Weymouth compressor station can reasonably be located away from tidal or inland waters?
I guess I go back to the scope of my testimony. As an environmental consultant, we were asked to review the alternate sites and the existing sites to conduct an evaluation of that, reviewing that to basically evaluate whether they were the site would be required and whether it would avoid or minimize environmental impacts to the Commonwealth resources. So, and that was the scope of our assessment.
And fair to say that you don't have the technical expertise to understand whether locating the compressor station somewhere other than the north parcel is or is not technically feasible? That's not your area of expertise, is it?
No, that's beyond, my area of specialty and professional experience. That's in the realm of Algonquin and the pipeline operators to determine on their side where the station needs to be from a technical standpoint with the suction and discharge lines and all the hydraulics of their system.
Thank you, Mr. Paquette. Chief Presiding Officer Gio Landino, for the same reasons that I articulated ending my cross-examination of Mr. Durain early, I would like to, with the Chief Presiding Officer's permission, bank any remaining time I have to allocate to my cross-examination of Ms. Hobbs.
You have 6 minutes left, so if you added to the 32 minutes before, you have 38 minutes now. Is that understood?
Yes, thank you.
Sure. And that's my fancy timer beeping, if you're wondering what that noise in the background is. In any event, Ms. Hill, I'm going to allow you to ask redirect questions, but first, so to make it an efficient process, I'll let Mr. Bragg ask any questions he has so that you can have a complete picture for you to utilize for your redirect. And I will say to Mr. Bragg what I said with respect to the cross-examination of Mr. Durain. DEP's cross-examination of Mr. Paquette, it's a misnomer because Mr. Paquette is not a hostile witness. And so I request that DEP counsel tailor the questions to reflect that fact. In any event, I'm going to give you 10 minutes. I assume, Mr. Bragg, you're going to be doing the cross-examination. I know Mr. Leeson and Mr. Hopper are here from the Office of General Counsel. I'm assuming it's you, unless it's someone else.
That's correct. It is me.
Sure. So you have 10 minutes, Mr. Bragg.
Okay. I won't need all of that. I really just have one follow-up question in light of
Sure.
Mr. Hayden's cross-exam. So, hello, Mr. Paquette. How are you?
Hello, Mr. Bragg.
I would just have one question for you. In your analysis, looking at this through the lens of Chapter 91's regulations, would you say it's an accurate statement to say the gas compressor station is operationally related to the hub line?
Objection. The basis, Chief Presiding Officer, is that where this is not a hostile witness, I would object to any leading questions being asked of this witness during any redirect examination.
Mr. Bragg, you can ask the question, but in a different form.
Sure. How would you describe, Mr. Paquette, the relationship between the compressor station and the hub line itself?
It's my understanding that compressed gas, additional pressure is needed in the I-10 hub line system. Algonquin has proposed this compressor station and built it at the existing site to satisfy that pressure issue, and based on that it's operationally part of the hub line connecting to it with the suction and the discharge lines.
Thank you, Mr. Paquette. No further questions.
Thank you, Mr. Bragg. Ms. Hill, your witness for a redirect, 20 minutes.
Thank you. I have just a few questions. Mr. Paquette, Mr. Hayden asked you about paragraph 12 in your testimony, and in connection with that asked about lengths of pipeline. Do you know how long the suction and discharge pipelines for each of the alternatives would need to be?
I do.
And how do you know that?
I know that because Algonquin provided us with alternate sites and potential or proposed routing of suction and discharge pipes that would need to be constructed in order for those alternate compressor station sites to operate and satisfy the needs of the Atlantic Bridge project. And those measurements were made based on mapping information where we were able to identify specific lengths of
And did you look at the impacts of the various lengths of suction and discharge pipelines associated with each alternative?
Yes.
And what were those impacts?
The impacts from the suction and discharge lines, it's significant. The routing basically covers both environmental and community impacts. For example, the line, the suction and the discharge line, that is from the Franklin alternative site, which is site number 1 in our report, the Epsilon report. That discharge line would need to be about 30.8 miles in total length to run from a station site in Franklin up to the discharge point at the I-10, the hub line, I-9 interconnection area. In order to construct a pipeline like that, there would be significant impacts to in freshwater vegetated wetlands, both forested wetlands, scrub, shrub, emergent wetlands, I think well over 70 acres just based on Mass GIS DEP data layer analysis, impacts to Article 97 properties, which are conservation land that is held with conservation purposes. There'd be impacts to tidelands as well, from the standpoint that all of the alternative sites and the discharge lines all would cross the 4 river flow tidelands in order to access the North Weymouth area, coming on shore and the Calpine 4 River Energy Center property and making its way up to the tie-in point on the north parcel. So again, just the significant level of impact that's not at all connected to the existing compressor station site.
So to be clear, all the alternative compressor sites include impacts to Chapter 91 jurisdiction?
That's correct, yeah, because all of the discharge pipes running and connecting those compressor station sites up to the I-10, I-9 interconnection would need to cross that 4 river area, which is about a 3,751 foot crossing of flowed tidelands.
I have no other question.
Thank you. We're at 12:16. We can break for lunch for an hour and then resume the hearing with the cross-examination of Ms. Hops. Does that sound acceptable to council?
It does, Mr. Chief Presiding Officer. May I be allowed a brief recross based upon the scope of the redirect?
All right, I will, well, you have some bank time to use, but I think it's fair to limit you to about 5 minutes.
Yes, that's all I will need.
Sure, and Mr. Bragg and Ms. Hill, if there's anything that occurs as a result of Mr. Hayden asking questions, if there's something from the answers that you believe you need to ask questions, you may, but also for a limited scope. All right, is that understood?
Yes.
Understood.
Yeah, thank you.
Understood.
Go ahead,
Thank
Mr.
you.
Hayden. So,
Thank you.
Mr. Hayden, why don't we do this? Why don't you go, it's 12:17 now, go to.
So I'm sorry, we lost your audio, Mr. Chief Presiding Officer.
Sure. Why don't we do this? Why don't you go to 12:30? It's more than the 5 minutes, but just for the sake of moving it along. And likewise, I'll give leeway to Ms. Hill and Mr. Bragg as well. Okay? Is that
I
acceptable?
appreciate it.
Is that
I appreciate it.
acceptable to you, Mr. You're welcome. Are you acceptable to you, to Ms. Hill and Mr. Bragg?
Yes.
Yes.
Okay, thank you.
Mr. Paquette, you testified on redirect that you evaluated community impacts of the proposed alternate locations for the compressor station. Do you recall that?
Yes,
Did you evaluate the community impacts that the Weymouth compressor station at the north parcel would have on the densely populated local community living in that neighborhood?
it was part of the analysis. Is we identified the number of residences within a half mile of the compressor station sites, both the existing site and the alternate sites, as well as within, I believe, 50 feet of the suction and discharge pipelines as well.
Okay. And my question specifically is, did you evaluate the community impacts to the citizens living in and around the Weymouth compressor station, including your representation that you looked at number of residences within a half mile?
We evaluated under that heading of community impacts. We looked at and those it's just an organizational thing in the report that would capture impacts that are not your traditional natural resource impacts. So, for example, the construction of the in historic or archaeological sites. We examined that. I mentioned Article 97 land. We looked at that because that's that land is set aside for for public use in most cases. So we looked at those types of features with the goal of looking at it from that standpoint.
Okay. The Article 97 land that's cited in Resource Report 10 is the Kings Cove Conservation Area, correct?
The Kings Cove Conservation Area is adjacent to the Algonquin property along Kings Cove, and I believe it is mentioned in the Resource Report 10. I have to flip it open to check it though.
That's okay. It is there, so you're correct. Did you evaluate the impact the compressor station would have to the adjacent Kings Cove Conservation Area and the Weymouth residents' ability to use and enjoy that conservation area after the compressor station is built?
That was not part of the scope of the work that I did here for this proceeding that we're talking about right now.
Why not? You evaluated community impacts for all the alternate locations. Why not evaluate the community impact for the local residents whose ability to use and enjoy the Kings Cove Conservation Area, which is adjacent to the north parcel, how that impact would result from the compressor station being constructed and operated?
If memory serves, under the previous waterways proceeding, we had discussed specifically the use of the Kings Cove Park and the Algonquin station, the fact that the station itself wasn't going to be impacting the park in the sense that there was no encroachment of the station site and access would be maintained through construction. That was my recollection from that. And then for the purposes of this analysis, we just this was a supplemental analysis to the Resource Report 10 that we prepared, where we tried to just build upon some of the features that were identified in Resource Report 10. So, for example, as you indicated, there are a number of residences within a half mile of the Weymouth compressor station site, but that's also the case for the three other Weymouth alternate sites, 3, 4, and 5, which are to the south of this particular area. There's also a similar number of residences within a half mile radius of those proposed compressor station sites as well. So I
understand your review of the community impacts to the other proposed alternate locations. What I'm trying to understand is why and these are your words, correct me if I'm wrong, it was not part of your scope to look at the impact that the Weymouth compressor station would have upon the use and enjoyment of the local community of the Kings Cove Conservation Area, which, as you correctly noted, is located adjacent to the north parcel.
I did not specifically go into a blow-by-blow analysis of each Article 97 property that would be affected by both the existing site or the alternate sites because of this really the significant number of Article 97 properties that would be affected by the alternate site. So that wasn't, when I say it wasn't part of our scope, part of our scope was to demonstrate the large number of sites that would be directly crossed and impacted by alternate site, suction discharge lines. And then even in one case with Weymouth alternate site 3, that site footprint actually encroaches on a map or area designated as Article 97. So it was an attempt to demonstrate that although the Weymouth compressor station is adjacent to an Article 97 property, the other alternatives have significantly more impacts to Article 97 property because of the fact that there actually would be crossings of those.
Okay, but you don't disagree that the Kings Cove Conservation Area Article 97 property is directly impacted by the construction and operation of the Weymouth compressor station in its current location, right?
I don't agree with that statement. The compressor station is not in the park. It's not encroaching on the park, to my understanding. So I can't confirm that statement.
Okay, I didn't ask you whether it's in the park. I agree with you, it's not. I didn't ask with you whether it's encroaching on the park. I may disagree with you, but my question is the Article 97 Kings Cove Conservation Area directly impacted by the, and those are my words, directly impacted, because that's language that you've used today. Is the Article 97 Kings Cove Conservation Area directly impacted by the construction and operation of the Weymouth compressor station in its current location?
Objection, asked and answered.
I agree it was asked. I disagree it was answered.
I think you've covered this territory, Mr. Hayden, so if you could move along. I mean, from my perspective, so I'm going to sustain the objection.
Mr. Paquette, have you evaluated any other potential locations for a compressor station along the Algonquin pipeline that would satisfy the applicant's needs other than the 7 alternate locations identified in Resource Report 10?
No.
Mr. Paquette, have you evaluated whether or not the applicant can add compression to the Algonquin pipeline anywhere other than the Weymouth compressor station in order to move gas from south to north?
No, I haven't evaluated that.
Have you evaluated whether or not Algonquin can ship gas from south to north to satisfy its customer needs without adding any compression to the existing pipeline?
No, I did not.
Have you evaluated whether or not Algonquin can ship gas from south to north to satisfy its customer needs by reducing the pressure in the I-10 pipeline to allow gas to flow freely from south to north?
No.
Mr. Chief Presiding Officer, those are all the questions that I have on recross.
Thank you, Mr. Hayden. Ms. Hill, I will do what I did before, let Mr. Bragg go first with the understanding that Mr. Paquette is not a hostile witness. And then I'll let you, since you had only used 6 minutes of your 20 minutes for redirect, you have 14 if you choose to use it. Mr. Bragg, do you have any questions for Mr. Paquette?
I have no additional questions for Mr.
Sure.
Paquette.
Ms. Hill, you have 14 minutes if you choose to use it. Go right ahead.
I don't think I will use all 14, but I have just a few questions.
Sure.
Mr. Paquette, does section 5.2 of your report analyze human and community impacts?
Yes.
And what are the categories that section analyzes?
That section covers noise, site access and transportation impacts, Article 97 land use and zoning, historic structures or districts and archaeological sites, and visual impacts.
And does section 5.2.1 explore those impacts related to the existing site?
Yes, it does.
And are there environmental impacts associated with these categories?
Yes.
What are they?
the categories that I just listed off?
Yes.
Is that what you're asking? Let me just bring that this. This is that.
I can pull up an exhibit for you if that's helpful.
If you can share the screen, that would be great.
Yes, I'm gonna pull it up right this moment. Oh yeah, that'd be great, Michael. Michael is faster than me, so he's gonna share his screen. Just the table of contents if you've got it.
Okay.
5.2.1. So my question was, does this section deal with the existing site?
Yes.
And then the follow-up question was, do these categories also include environmental impacts?
Yes.
And what are those?
Well, to give you an example, 5.2.1.2, that particular evaluation criteria looked at how one would access a compressor station site or the alternate compressor station sites in comparison to the existing site in North Weymouth. Just for background, the existing site is located in an area where there was no need to construct new access roads to get to a public road to provide construction and operation access. In contrast, alternate sites all would require the construction of new access roads, again, for construction and operation. And in some locations, specific more the Franklin and the Holbrook locations, those sites are in relatively rural areas, which require tree clearing, potential impacts to wetlands, addition of impervious surface where there currently is none. So there's a level of disturbance related to those alternate sites to access the compressor station locations, again, in comparison to the existing site where there's none. And then the other part of that was just basically describing the potential transportation impacts from the alternate sites and pipelines versus the compressor station as well. Looking at construction equipment, talking about how that equipment would have to be brought in. There's potential for noise and disturbance of dust generation, all the things that one would associate with a construction project. The alternate sites, because of the fact that you would need to build these long lengths of suction and discharge pipe, would basically stretch those impacts out across the entire community, as opposed to being contained in one specific finite location. So that was the background there for that as an example.
Thank you. I have no further questions.
Thank you, Ms. Hill. I was planning at this point to recess for lunch for an hour, if that is acceptable to counsel for the parties. Mr. Hayden,
Yes, thank you.
Mr. Cram or Ms. Hill,
Yes.
Mr. Bragg. All right, it's 12:32 right now. It's not quite an hour, but can reconvene at 1:30? Is that fine with everybody? All right, so we will have a recess until 1:30. We will reconvene at 1:30. Thank you very much.
We are. Hi, Carol. This is Katie. How are you?
Well, thanks.
I got your email with some questions, and I will respond as soon as we wrap up. I just didn't want to leave you
No,
hanging.
you guys are busy. I thought I'd just slip those in. So thank you.
Yeah.
Carol, we realized we didn't ask as we got started, but is the connection and your ability to hear all of us working okay?
Outstandingly well. Yes. Thank you.
Oh, great. Thank you.
Thank you for asking. These things can be a little iffy, but everybody's nice and clear. Thank you.
Hello again. Thank you for coming back. Sorry to be a little late. So we will now commence the afternoon session of the today's hearing. The remaining witness to be cross-examined is Christine Hops, who's the Assistant Director of Mass DEP's Chapter 91 program. Mr. Hayden, you had 30 minutes of banked time from the other witnesses that you cross-examined. So you'll have a total of 70 minutes to cross-examine Ms. Hops. And DEP and Algonquin will have, Algonquin will have 15 minutes to ask questions, and DEP 30. And since we have flexibility because it's slightly past 1:30 and we plan to conclude at 5 p.m., I mentioned that as well, that there is some flexibility. I don't want to go beyond those, really much more than those time periods, but I figure I'd tell you up front what the starting parameters are so we can work with that. And then at the end, I just wanted to chat briefly when the hearing concludes. Just want to chat briefly with counsel regarding the schedule for filing closing briefs and oral argument of counsel, but we will deal with that later after Ms. Hops's cross-examination is concluded. So at this juncture, I take it, Mr. Bragg, you're still lead counsel for the cross-examination or presentation of Ms. Hops?
That's correct.
Okay, so
Sorry to interrupt, Mr. Chief Presiding Officer Bruce Hopper for DEP. Just with respect to Ms. Hops' testimony, cross-examination, I'm not the best at math, but it looks like it's almost it could add up to approximately 2 hours of testimony. And I'd rather bring that up now. If at any point she needs a break or where we think that would most be appropriate for her to break. Again,
Sure.
Given that it's almost 2 times what any, and maybe actually even longer than any other witness that has testified. So I just want to bring that up now.
Well, thank you, Mr. Hopper. I appreciate that. And, the reason, it's more for Ms. Hops is because of the fact that Mr. Hayden did not take as much time cross-examining the other witnesses. That's where the position we find ourselves in. But thank you for bringing up the issue about having a break. I think you've everyone has noticed this morning that about the hour and a half mark, I have called for breaks, with this past one being the lunch break. And so why don't we do this? After the 1 hour mark, I can check in with everyone and see how Ms. Hops is feeling, if she needs a break, and anybody else who needs a break. Is that acceptable to everyone else? Mr. Hayden?
Yes, thank you.
Ms. Hill, Mr. Cramp?
That sounds good to us. Thank you.
Okay, and I take it that's acceptable to you, Mr. Hopper, speaking on
Yes,
behalf of your colleagues. Okay.
Thank you, Mr. Chief Presiding Officer. Much
You are
appreciated.
welcome. Thank you for bringing up a very important, matter. Mr. Bragg, do you want to proceed now? And well, first, I'll acknowledge that Ms. Hops is with us today. And I see you, Ms. Hops. Ms. Hops, do you promise to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. And so, Mr. Bragg, if you can ask the customary questions that are posed to a witness for adoption of pre-filed testimony, you can do so at this point. However, I will accord you the same courtesy that I accorded to the petitioner's witness, Dr. Sehu, and the applicant's two witnesses, that you can ask some questions of Ms. Hops regarding her background, and then proceed to the adoption of the pre-filed testimony. Only if you and Ms. Hops feel that you want to do that. You can go straight to adopting the pre-filed testimony or give background information.
Sure. Thank you, Mr. Presiding Officer. Good afternoon, Ms. Hops.
Good afternoon.
Can you just state briefly for the record what your position is with the department?
Christine Hops, Assistant Director of the Waterways Regulation Program.
Okay, thank you. And did you file pre-filed direct and rebuttal testimony in this matter?
Yes, I did.
And did you sign that testimony under the pains and penalties of perjury?
Yes, I did.
And are there any corrections you would like to make to this pre-filed testimony?
Yes, there's one correction that's a typo in my rebuttal testimony. It's in number 10 on the last page, where there is a reference to section 60 of chapter 30 MGL. That should be section 61 of chapter 30.
Okay, can you bear with me? This is on the last page of your rebuttal pre-filed testimony?
Yes, that's correct.
Okay, and where in the testimony you're referring to?
Number 10, it's the last page where
Yeah, I do. I know that. Where in the last page regarding the text that you want
about
to?
mid paragraph. It
Okay.
says section 60.
Yeah,
That should be section 61.
okay, thank you. Any objection to Ms. Hobbs making that correction?
Not from the petitioners, thank you.
Mr. Cran, Ms. Hill, any objection from Algonquin?
No.
Okay. You can proceed, Mr. Bragg. I figured I'd ask the council if there were any objections to that correction.
Okay, thank you. With that correction made, do you adopt this testimony as your own?
Yes, I do.
Okay, as a result of Ms. Hobbs adopting her pre-filed testimony, both direct and rebuttal, are now officially part of the record. She is now available for cross-examination for 70 minutes, and therefore I turn it over to you, Mr. Hayden.
Thank you, Mr. Chief Presiding Officer. Good afternoon, Ms. Hops.
Good afternoon.
How long have you been Assistant Director of the Waterways Regulatory Program?
Approximately 5 years. I started in 2018.
In that time, other than the instant matter that we're here for today, have you reviewed any other applications to add a proposed ancillary facility to a previously licensed infrastructure crossing facility?
Yes, I have.
And what were they?
It was one, Eversource East Eagle Substation, located in East Boston.
What year was that?
That was the application initiated, I want to say around 2015. I became involved after I joined the department, and it concluded, gosh, earlier this year, maybe January. I'm sorry, I don't know the date.
I can provide the date on that. It is a little beyond the scope of her testimony, but it was resolved by the EFSB last November 30th.
Thank you, Attorney Bragg. In your 5 years with the department, Ms. Hops, have you had occasion to get to know Presiding Officer Rothschild in the Office of Appeal and Dispute Resolution?
I don't know. I honestly don't remember whether I've had any appeals with her. I don't know her personally.
Have you had any appeals at all?
Yes.
do you have an understanding as to Mr. Rothschild's reputation as a presiding officer?
I do not.
In your 5 years with the Waterways Regulatory Program, have you ever, in a written determination, reversed the recommended decision of a presiding officer other than the matter we're here for today?
I have not.
I'd object. That's a mischaracterization of where we are.
I think I agree with Mr. Bragg, Mr. Hayden. And so what I would ask is that you rephrase the question. I know that in play or at issue is presiding officer Rothschild's recommended remand decision of last June, where she determined, following the remand from the Superior Court, that the compressor station is not an ancillary structure in accordance with the Chapter 91 regulations at issue in the appeal. I think everyone agrees that that's what's the major focus here today. So to the extent you ask a question whether or not she agrees with what Judge Rothschild determined, I think that's fair game to ask. Given that there has been, I believe in Ms. Hobbs's testimony that, based on additional data, and I don't want to put words in Ms. Hobbs's mouth, but basically the word new or additional. So I think it's fair game. You can ask, those kind of questions. Is that clear, Mr. Hayden?
Yes, thank you, Mr. Chief Presiding Officer.
Sure.
And what I'll do is I'll share my screen so that we can look at Presiding Officer Rothschild's recommended remand decision. Ms. Hobbs, are you seeing that document on your screen?
Yes, I am.
Have you had an opportunity to review this document before?
I have.
On page 4 of Ms. Rothschild's recommended remand decision, do you see the paragraph above the section heading titled background?
Yes. Is it possible to make it larger? Perfect.
How's that?
Thank you.
Would you read the last sentence above that heading background, please? The last full sentence, starting with "I have made."
I'm not sure that's shown on the screen. Oh, yeah, sorry. I'm sorry.
That's
I found
okay.
I have made these recommendations because a preponderance of the evidence applying the definition of require as determined by the Superior Court in its decision supports a finding that the compressor station does not require a location adjacent to the hub line because it can reasonably and feasibly be located in one of several alternative locations, and it is not integral to the operation of the infrastructure crossing facility.
In your review of all the materials in this matter, did you agree with Ms. Rothschild's statement that you just read?
Not entirely.
Okay, tell me the parts you do agree with.
I agree with that she made an assessment based on the administrative record before her at that time. So that I don't disagree with that portion of her decision, but towards the end where it states it is not integral to the operation of the infrastructure crossing facility, that isn't consistent with the language in the definition, where it states that it's operationally related, not operationally integral or required. So that's the piece that I don't agree with.
So you agree with everything before not integral?
Again, I don't know that I agree with the outcome, but I understand that the basis for her decision was the administrative record she had at the time that she did this determination.
Which included what?
It didn't include the most recent review of the project in the context of the Chapter 91 regulations and the word require as identified by the Superior Court decision.
I'm sorry, Ms. Hobbs, I asked a different question. What did the administrative record that Ms. Rothschild review include?
I couldn't state everything that's in there, but in this decision, in a different section. I'm not sure where. It states that her decision is based on the administrative record that she has. I'm paraphrasing. I suppose I could look if you'd like me to find a statement.
I'd object to this. She can speak to what is in the record, but she can't really speak to every piece that President Officer Rothschild evaluated and how Ms. Rothschild evaluated it prior to Ms. Hopp's involvement in this case.
Objection, Mr. Bragg?
That is an objection, yes.
Okay. I do agree with Mr. Bragg regarding how the question has been phrased. I will take administrative notice that when the term administrative record is referred to, that refers to all the documents that were filed in the appeal, including pre-filed testimony. I can also state, based on Presiding Officer Rothschild's recommended remand decision, that when she made reference to the administrative record, she was referring to the pre-filed testimony of the witnesses who testified in the first hearing, and and documentary evidence that was in the record. Does that help counsel for the parties? Given that background information, then we can proceed from there.
Yes, thank you.
Did I hear you say yes, Mr. Hayden?
Yes, thank you, Mr. Chief Presiding Officer.
Sure. Ms. Hill, Mr. Cram, you agree as well?
I think so. That the point is that Ms. Rothschild considered the administrative record that was before her at that time, which is different from what it is now.
Thank you, Mr. Bragg.
Yes, I agree that she considered the administrative record as of the time of her decision last summer, prior to the interlocutory remand order by the commissioner and the additional analysis.
And thank you for that. And all the parties agree that as a result of former Commissioner Suberg's interlocutory remand order, which followed Presiding Officer Rothschild's recommended remand decision, that put in operation the circumstances that we find ourselves today, where additional information was supplied by Algonquin through the pre-filed testimony of the witnesses who testified today. And then that was responded to by the expert testimony of the petitioner's expert witness, Dr. Sahu, who was cross-examined today. And the department also responded through the pre-filed testimony of Ms. Hopp's, both direct testimony and rebuttal. Does that accurately sum up what occurred? I take that as a yes, Mr. Bragg?
Yes, I agree with that, yes.
Thank you. Mr. Hayden, you can proceed.
Thank you. Ms. Hops, what part of the administrative record considered in the underlying proceeding did you review in connection with this matter?
The majority of my review was based on the information that was provided subsequent to the interlocutory remand order, but I also did review the rest of the application.
Okay. Did you review any testimony from the trial that Judge Rothschild presided over?
No, the actual, I don't have transcripts of the testimony. I did review portions of the testimony that were referenced, and the pre-filed testimony of the department. I know at some point earlier on, I did look those over.
Okay. So, and forgive me, we haven't had a chance to speak ever before, have we?
I don't believe so.
Okay. So I don't know what you looked at. I'm just trying to understand the universe of documents that you considered in reaching your determination. So you did not have a copy of the transcript from the trial that Judge Rothschild presided over. Is that fair?
That's correct.
Right. And any portions of the testimony from the underlying proceeding that you did review were limited to those that were cited in Judge Rothschild's recommended remand decision?
There were also citations in various other pre-filed testimony. And I'm trying to think if there were any others, but there were a number of citations to prior testimony that were in subsequent filings. So in response to the commissioner's interlocutory remand order.
Did you review any of the petitioner's pre-filed testimony from the underlying proceeding?
I may have, when I was doing the original review, I don't remember details.
Did you review the town of Weymouth's witness, William Powers' testimony from the underlying proceeding, pre-filed direct testimony?
No.
Did you find any occasion where Judge Rothschild inaccurately summarized testimony that is cited in her recommended remand decision?
I didn't do a review of the decision in, I guess, to that level of detail, looking for, are there errors in any of these locations? What I did was review it for context and so that I could have an understanding of what had occurred previously. And
I'm not suggesting that you should have or did. I just want to know if you did, whether you found any errors in Judge Rothschild's description of the testimony cited in her recommended remand decision.
errors in her description of the testimony cited?
Correct. For example, at the bottom of page 5 that I'm showing you, it says the hub line has functioned without a compressor station since it was built and does not need a compressor station to function. Transcript day 1, page 235, lines 12 to 18.
I did not do any cross-check of those citations.
Okay. So fair to say you have no basis to dispute the accuracy of Judge Rothschild's citations to the hearing transcript.
Agreed.
I'd object. That's beyond the scope of her testimony.
Sustained, Mr. Bragg. I think Ms. Hobbs has pretty much explained what she reviewed and didn't review. And so, Mr. Hayden, if you can move along with the questioning, I think, I mean, it's fair game to cross-examine Ms. Hobbs on, you know, what she relied on. And I think she's answered several times, but if you can move along. Sure.
Turning your attention to page 11 of Judge Rothschild's recommended remand decision. Do you see the second full paragraph on this page, beginning with the infrastructure crossing facility?
Yes.
Would you read that sentence for us, please?
The infrastructure crossing facility, the hub line, has functioned without a compressor station since it was built and does not need a compressor station to function.
Do you agree with that statement?
I don't have an opinion on that statement. I'm not technically familiar with the operation and what it may need to function.
Fair enough. Turn your attention to page 12. You see the first full paragraph below the block quote, beginning with the applicant acknowledged?
Yes.
Would you read that sentence for us, please?
The applicant acknowledged that the project purpose of increasing pressure in the pipeline could be achieved by adding compression at a location other than adjacent to the hub line.
Do you agree with that statement?
I don't have an opinion on that statement for the same reason.
Isn't that statement important for your determination of whether or not the compressor station meets the ancillary facility definition under the waterways regulations?
No, I don't believe that statement is.
Why not?
Well, this is discussing the need for the compressor station, which isn't relevant to the Chapter 91 application. It's what's relevant.
I didn't mean to interrupt. Please go ahead.
What I was going to say, what's relevant is whether it meets the definition of an ancillary facility. and whether it requires an adjacent location.
Okay. Do you have your rebuttal testimony in front of you?
Yes, I do.
Would you turn to paragraph 8, please?
Yes.
See the second sentence as specified?
Yes.
Would you read that sentence for us, please?
As specified in the department's review pursuant to the IRO at HUPS PFT Exhibit 2, page 5, number 1, the department found that the hub line requires the compressor station as it is essential to the current and anticipated purposes of the hub line for the foreseeable future.
So you did reach a conclusion that the hub line requires the compressor station.
Yes.
And it's your testimony that the cited language that's in front of you on page 12 of the recommended remand decision from Judge Rothschild, citing Mr. Bocock's pre-filed testimony at page 15, lines 325 to 327, in which Judge Rothschild describes the applicant acknowledged that the project purpose of increasing pressure in the pipeline could be achieved by adding compression at a location other than adjacent to the hub line. In your mind, that's irrelevant to your conclusion that the hub line requires the compressor station?
I'd object. I believe counsel is conflating required in two different ways.
Can you explain that further, Mr. Bragg, for the record?
Yes, required under the definition of an infrastructure crossing facility and its ancillary facilities doesn't say that the ancillary facility is required for the operation, only that its location is required to be next to it and that it be operationally related to.
Okay.
So the key phrase is operationally related to, not that it's essential for the infrastructure crossing facility to work.
I think a fair question, Mr. Hayden, would be based on the regulation at issue. How did Ms. Hobbs arrive at her determination that it's an ancillary structure?
I agree, Chief Presiding Officer. I'm trying to explore the universe of the information that was considered by Ms. Hobbs in reaching that conclusion. And
Okay.
quite frankly, I'm surprised that she didn't read the hearing transcript. I'm surprised that she didn't find this sentence written by Judge Rothschild to be relevant to her review. So if I could be granted a little bit of leeway to further explore the foundation for her decision, then I do intend to ask the question that you've asked, which I believe is sort of the central question at issue.
I would object that that would be beyond the scope. Ms. Hobbs was tasked with examining new information submitted subsequent to the interlocutory remand order.
That's true, Mr. Bragg, but it is also a fair question for Mr. Hayden to ask if she reviewed anything else. And the previous testimony from the first hearing, that's part of the record. So I think it's fair for Mr. Hayden to simply ask the question, and then I'd ask you to move on from it, Mr. Hayden. I just asked Ms. Hobbs what she relied on in making this determination that's currently on appeal before me. I think limiting to that, and then from that, if there are further follow-up questions, I would state that you could proceed from there. But I think the bottom line is, what did Ms. Hobbs rely on in making her determination that's on appeal before me? That's
Understood.
A fair question.
Thank you. Ms. Hobbs, what information did you rely upon in making the determination that's on appeal before the Office of Appeal and Dispute Resolution today?
I relied upon the supplemental alternatives analysis, also the pre-filed testimony that was filed subsequent to the interlocutory remand order. Those were the things that I relied on. I also considered, like I said, the review of other information prior to that.
Why didn't you review the hearing transcript?
I don't have,
Objection. Again,
And,
he's going beyond the scope of her testimony.
I think, Ms. Hops answered, and correct me if I'm wrong, Ms. Hops, I don't want to put words in your mouth, that you didn't review the transcript, is right?
that's correct.
Okay, I think that's sufficient, Mr. Hayden.
Okay.
Yeah, what I can infer any inference from that, and you certainly, in the petitioner's closing brief, can make an argument what that means, and likewise, DEP and Algonquin in their respective closing briefs can respond as to what that means.
Understood.
And I take no, I want the parties to know, I take no position on, whether or not that was appropriate for Ms. Hops to do. This is to scope out or find out what Ms. Hops relied on, which is, again, that's all. But I make no judgment whatsoever as to whether her review was appropriate or not. I just want the parties to know that. So you can go ahead, Mr. Hayden.
Thank you very much. Still drawing your attention, Ms. Hops, to page 12 of Judge Rothschild's recommended remand decision. Do you see in the middle of this paragraph toward the right side where a sentence begins each of the alternative locations?
Yes.
Would you read that sentence for us?
Each of the alternative locations for the compressor station is technically feasible.
Do you agree with that statement?
I don't have an opinion on that statement.
Is that statement not relevant to your determination of whether or not the Weymouth compressor station is an ancillary facility to the hub line?
So I don't disagree with it. I don't have the technical background to say whether something could be cited at an alternative location based on technical details. I guess that's what I was trying to clarify.
Okay, so you have no reason to doubt the validity of that statement. Is that fair?
That's correct.
Would you read the next sentence for us, beginning with the applicant determined?
The applicant determined that each of the alternative locations for the compressor station was reasonable.
Do you have any basis to doubt the validity of that statement?
I do not.
Turning your attention to page 13 of the recommended remand decision, in the paragraph that finishes above discussion's findings, the last sentence begins with the applicant admitted. Could you read that sentence for us, please?
Yes, the applicant admitted that from a technical perspective, the compressor station at that location is not essential to meeting the applicant's precedent agreements with its customers, and it could be located elsewhere and meet those agreements.
Do you have any basis to refute the accuracy of that statement?
No.
At the bottom of page 13 on the recommended remand decision, would you read the last two sentences for us, beginning with the regulation requires?
The regulation requires a determination that something is ancillary based on more than just its intended placement in a DPA adjacent to the ICF. Its location there must be required.
Do you agree with that?
I do.
On page 14 of the recommended remand decision, top paragraph, last sentence, beginning with the regulation does not. Would you read that sentence for us, please?
The regulation does not apparently contemplate considering that an alternative location may present greater engineering and or economic challenges and costs to the applicant.
Do you agree with that statement?
I do not,
Why not?
because the regulation doesn't qualify the factors that can be considered in determining whether something is required to be located in an adjacent location.
What factors did you consider in determining whether or not the compressor station requires an adjacent location to the hub line?
My analysis was based primarily on Chapter 91 interest, or I would say entirely. I did review the other factors that had been raised, but the Chapter 91 interest is what my determination was based on.
What are Chapter 91 interests?
And this preservation of public trust rights, water dependent uses. In this case, because it's in a DPA, water dependent industrial use.
What does preservation of public trust rights mean?
Access to the water for fishing, fouling, navigation.
And how does allowing the construction and operation of a natural gas compressor station on the north parcel preserve public trust rights?
It's an ancillary facility to a water dependent industrial use, which is allowed by the regulations.
Okay, so are you saying that it's an exception because it doesn't promote fishing, fouling, and use of the Chapter 91 waterways? Or are you taking the position that building and operating a compressor station actually promotes public trust rights?
That's
Objection. She's stating that it complies with the regulations.
Are you stating that the regulations?
Mr. Hayden, wait. Mr.
I
Hayden,
apologize.
Well, Ms. Hops did testify. Again, Ms. Hops, if I'm putting words in your mouth, please correct me. But my recollection reading Ms. Hops's testimony is that part of her determination involved a finding on her part that locating the compressor station someplace else would adversely impact Chapter 91 interests. Is that right, Ms. Hops? Did I
Yes, that's correct.
Okay, and therefore it is fair for Mr. Hayden to ask Ms. Hops to itemize what those Chapter 91 interests are. So with that, I believe, Mr. Hayden, you can ask that question for an itemization as to what are the Chapter 91 interests that Ms. Hops considered in making her determination. Mr. Bragg, do you have an objection to that?
I believe that's been asked and answered, but if he has a follow-up,
Okay. I'll let you ask it again, Mr. Hayden, just to keep the witness questioning flow going. And so ordinarily I wouldn't, but this time, because I think it would be good for everyone, especially for the individuals who are viewing on the YouTube, Mass DEP's YouTube channel, to get an understanding. And again, it's not a judgment on whether or not Ms. Hops acted appropriately here. This is to get to the truth of the matter. So with that being said, I'll let you proceed, Mr. Hayden.
Thank you very much, Mr. Chief Presiding Officer. Ms. Hops, just so my question is clear to you, I'm not asking whether or not the Chapter 91 waterways regulations allow you to authorize the construction and operation of the compressor station as an ancillary facility. Okay, that's not my question.
Okay.
My question is, what Chapter 91 interests did you protect in issuing a written determination that the compressor station is an ancillary facility to the hub line?
Water dependent industrial use.
Okay. Did you protect any other Chapter 91 interests? For example, Article 97 lands like the Kings Cove Conservation Area?
Article 97.
Mhm.
I'm sorry, I'm not sure I understand the question.
Sure. Let me pull up a document to help you. Give me one moment.
Are you going to shared screen, Mr. Hayden?
Yes, just I have to transition to a different document, so it'll just take me one moment to do that. Ms. Ops, are you seeing what is page 14 of the Epsilon Associates, Inc. Original Alternatives Analysis? Ms. Ops, did you hear my question?
Perhaps she's frozen.
Oh,
Yeah,
thank you.
I don't see her on my screen anymore.
Okay. Can one of DEP council contact Ms. Hops by cell phone or email?
Yeah,
So
I'll send her a message.
yeah, probably quicker to call on the cell phone. Perhaps you can do email and your co-counsel can try to contact her by cell phone.
Okay.
Chief Presiding
I'm
Officer,
sending her-
she's reported that her computer just went dark. She is working on it and should hopefully be right back.
Okay, thank you.
Sure.
I don't. While Ms. Hops is working with her computer, I just wanted to note the time. Mr. Presiding Officer, you are probably keeping track of it, but I just wanted to bring it to your attention.
I have at the when there's about 10 minutes left, I will ask if Ms. Hops wants a break.
Okay, thank you.
Mr. Bragg, would it be helpful if we had the break now and resume at 2:25? In the meantime, the computer issue, not to pry, but is she working from the office or from home? I'm only asking because of computer connections,
Yeah.
depending what your locale is.
Oh, she just sent me a message. She's in the waiting room.
Okay, so Mr. Ferson, can you let Ms. Hops in? Ms. Hops?
I sincerely apologize. My computer just restarted. I'm so sorry.
No need to apologize. We've all gone through these issues with the computer laptops that we've been provided by the agency. So why don't Mr. Hayden re-ask your question and proceed from there.
Thank you.
Yep.
And I believe she's disappeared from the screen once more.
Oh, no.
Let me send a quick note and see if she still can hear us.
She's coming back on from what I can see. Can you hear us, Ms. Hops?
I can. I apologize again. I don't know what just happened.
Like I said, we've all had these issues. We're at 2:15. Mr. Bragg did mention about taking a break. Are you comfortable continuing for another 10, 15 minutes and then we take a break?
Yes, I'm comfortable continuing.
All right, so why don't we go to 2:30 and have a break then? And then we'll be like for 10, 15 minutes and then we can resume. Is that fair to everyone? Everyone agree?
Yes,
Yes.
and can I just ask Carol, if you notice any connection issues, can you stop me mid-sentence so that we don't continue unnecessarily?
Certainly.
Thank you.
Thank you all. Proceed, Mr. Hayden.
Thank you. Ms. Hops, I'm sharing my screen. I'm showing you the top of page 14 from the Epsilon Associates Original Alternatives Analysis. Do you see that?
I do.
Have you reviewed this document in connection with your decision in this matter?
Yes, I reviewed this document.
Do you see at the bottom of the screen the section entitled Open Space, Article 97 Land?
Yes.
Would you read that paragraph for us?
The existing site is adjacent to the 2.9 acre Kings Cove Conservation Area. The Kings Cove Conservation Area is the subject of a conservation restriction pursuant to GL Chapter 184, Sections 31 through 33. The Lovels Grove parcel is a 1 acre public open space located along the shore of the Weymouth Fore River, south of Bridge Street. Neither the Kings Cove Conservation Area nor the Lovels Grove parcel are located within the existing site.
Thank you. Did you have that understanding that adjacent to the existing site was a 2.9 acre Kings Cove Conservation Area?
Yes.
What Chapter 91 waterways interests with regard to open space and Article 97 land did you protect in approving the ancillary facility definition for the compressor station?
I'm not clear on how Article 97 Article 97 land is becoming a Chapter 91 interest.
Or open space?
The project site doesn't include that area, the conservation area.
Understood, but your
What
review
we're
of
reviewing and
the,
licensing is the project site.
understood, but you reviewed a number of Article 97 areas in connection with your review of the proposed alternate sites, correct?
No, I'm not sure that I'm not sure what you're referring to.
Well, when we asked you before, what Chapter 91 interests did you protect? What's that answer?
In this location, you said, what did you protect here by allowing this compressor station? And I said, water dependent industrial use.
Okay. And is that it? No other Chapter 91 interests were protected in this location?
I'm protecting the Chapter 91 interests in other locations outside of here.
At the expense of the open space Article 97 land?
No, there isn't any impact to that space as a result of this project.
How could there not be? There's a public park next to what used to be open grassy tree-filled land that's now adjacent to a large-scale industrial natural gas facility. How is there no impact at all to open space Article 97 land protected by a conservation restriction?
There hasn't
Objection.
been any
She stated that she's
documentation.
protected other lands.
Yeah, I think she's answered the question, Mr. Hayden. I would summarize this line of questioning and then move on. That's my rule.
Thank you. I'm going to share my screen again with you, Ms. Hops. Page 14 of Judge Rothschild's recommended remand decision. Would you read the first sentence of the last paragraph, please?
As a result, it cannot be said that the location on the north parcel is required, i.e. is called for or as suitable or appropriate, because it is required, demanded, or made necessary.
Do you agree with that statement?
I do not,
Why not?
because the location on the north parcel is required when considered in the context of Chapter 91.
How is it required? Consistent with the definition handed down from the Norfolk Superior Court?
because it's a chapter 91 definition in the regulations, in the chapter 91 regulations. And when we're looking to require, and that definition called for as suitable or appropriate because it's required, demanded, or made necessary, the location that results in no appreciable chapter 91 interest impacts is the required location for that siting.
When was the infrastructure crossing facility licensed?
I think it was around 2002.
And for 15 years, that infrastructure crossing facility did not require, demand, or make necessary a compressor station. Do you agree?
That's not what the regulation, the definition of ancillary facility speaks to. It doesn't say that the hub line has to require the compressor station. It says the location has to be required. They only have to be operationally related.
Okay. Well, your pre-filed rebuttal testimony, paragraph 8 that we looked at before,
Yes,
you stated the department found that the hub line requires the compressor station.
yes.
Why is that?
I was actually, when I hung up on everyone, or I was looking back to what the referenced language in my prior pre-filed testimony, and I'm sorry, I've lost it somewhere in the shuffle, but that was, whether it's required or not, isn't the threshold for meeting that standard. So even if I'm to say, based on the information I have, that we believe this is required here, that's still not the standard for the operation. It's operationally related to. The keyword required only relates to the location, not to the interaction of those two facilities.
Okay, so that's your conclusion based upon the 5 years you've spent as assistant director of the Waterways Regulatory Program, that required applies only to the location.
That's correct.
And what's that based on?
A reading of the definition?
Okay, well, you agree that Judge Rothschild came to a different conclusion?
I do.
And you agree that she at least had an administrative record before her and drafted a 17-page recommended remand decision?
I agree that she had an incomplete administrative record before her.
Objection. Ms. Hopp's testimony was based on further information that was submitted after the recommended remand decision.
Well,
What
Mr. Bragg,
information-
She answered the question after Mr. Hayden asked it, so if you're objecting to future line of questioning on this topic, I'll hear it, but she already answered the question before your objection. So is there any objection that you want to make regarding future line of questioning regarding this topic?
Only that the implication that Ms. Hops was dealing with less information than was available to Judge Rothschild is incorrect, because she undertook her analysis subsequent to Ms. Rothschild's recommended remand decision under the auspices of the interlocutory remand order by the commissioner.
Okay. Thank you, Mr. Bragg. Mr. Hayden, if you can frame your questions along the lines Mr. Bragg has indicated, that would be great.
Of course. Thank you, Mr. Chief Presiding Officer. Ms. Hops, drawing your attention to page 16 of the recommended remand decision. Do you see the last sentence in the first paragraph beginning with the evidence demonstrates?
Yes.
Would you read that for us, please?
The evidence demonstrates pervasively that the compressor station can be located away from the hub line and still serve its purpose in the applicant's AB project.
And did you, just so our transcript is clear, did you say persuasively?
No, I didn't. Actually, I said pervasively. I'm sorry.
That's okay. How about let's just start that Q&A over, because that's what I thought I heard, and I just want to make sure our transcript is correct. Could you reread that sentence, please?
Yes.
Are you referring to in Judge Presiding Officer Rothschild's decision?
Page 16, Chief Presiding Officer.
Yes.
It's the top paragraph.
Yes, I see it now. Thank you.
The last sentence.
Yep. Thank you.
Yes.
The evidence demonstrates persuasively that the compressor station can be located away from the hub line and still serve its purpose in the applicant's AB project.
Do you understand what the applicant's AB project means?
It's the broader Atlantic Bridge project.
And
That's,
is that? Go ahead.
I was just gonna say, that's my understanding of it.
Sure. Is that relevant to your review of whether or not the compressor station is an ancillary facility to the hub line?
No, the question of whether the compressor station is an ancillary facility to the hub line is whether the compressor station is operationally related to the hub line.
Well, you said a moment ago that the word required applies only to the location, correct?
Yes,
And Judge Rothschild concluded that the compressor station can be located away from the hub line, correct?
as I mentioned previously, based on incomplete information as compared to what has been done today.
And what
I'm going to
information?
Excuse me, I'm going to step in here because I am concerned about how Ms. Hops, I am doing this on behalf of the appeals process, not on behalf of any party. The information that presiding officer Rothschild had for the record was based on the administrative record before her, which included the pre-file testimony of a number of witnesses and the Chapter 91 program's determination. So to phrase things, Ms. Hops, that it's incomplete, what the record before presiding officer Rothschild was complete. What
I'm
we're
sorry.
talking about is what followed then Commissioner Suberg's interlocutory remand decision. I think it's very important that we state that and confirm that for the record, because and I'm not inferring any malice or malintent on your part, because when you say incomplete, it suggests that presiding officer did not do a complete review of the issue. Okay?
Understood.
The council understand where I'm coming from here?
Yes.
Mr. Bragg,
Yes, I understand.
Mr. Cram, Ms. Hill? Hello?
Oh, we are.
I
Okay,
believe so. Sorry, I think we had a mute issue there, but yes.
well, thank you. So with that being said, you can continue, Mr. Hayden.
Thank you, Mr. Chief Presiding Officer.
Sure, we're 2 minutes from 2:30, just to let you know.
Absolutely. I'm
Sure.
happy to take a break whenever it's convenient to
Sure.
everyone else.
Why don't you ask another question, then we'll take a break. Does that sound fine, Ms. Hops?
Yes,
Sure, thank you.
Ms. Hops, what information do you have or did you receive and review that allowed you to reach a different conclusion than Judge Rothschild concerning whether or not the compressor station is an ancillary facility to the hub line?
I did an analysis of the different locations and the potential impacts in the context of Chapter 91. That was not something that the department had done previously as part of the earlier filings.
Okay. I'm happy to continue more if it's efficient, Mr. Chief Presiding Officer, but now is as good a time for a break as any. Oh, we have,
It's 2:29, we're almost at 2:30. Why don't we take a break for 10 minutes, reconvene at 2:40 PM? Is that acceptable to council and you, Ms. Hops?
Yes.
Okay, all right, so we'll resume at 2:40. Thank you
Mr.
very
Chief
much.
Presiding Officer, just so that I can organize the questioning I have left, do you have a current time on the clock?
Yes, you have 20 minutes left for cross-exam, which I'm going to freeze when we take the break. Okay?
Thank you.
Sure. Okay, is everyone back? Okay, we've resumed after a brief recess. Is everyone back? I see Mr. Bragg, I see Mr. Cram, I see Ms. Hill, and Mr. Hayden.
Thank you.
Okay, so Mr. Hayden, you have 20 minutes left for cross-examination time. And so I'm starting the timer now.
Thank you, Mr. Chief Presiding Officer.
Sure.
Ms. Hobbs, I'm sharing my screen again. This is page 16 of Judge Rothschild's recommended remand decision. The first full paragraph, beginning with the DPA regulations. Would you please read? Can you read that whole paragraph for us?
Sure. The DPA regulations make clear that tidelands available for industrial development are limited, and the strong implication is that the industrial tidelands in a DPA should be reserved for projects and facilities that need to be there and or enhance the resource itself, e.g. maritime-related activities. That is not the case with the compressor station. As well, the use of the phrase requires an adjacent location in 310 CMR 902 evidences a recognition by Mass DEP that coastal resources are limited, particularly coastal resources for industrial activities and facilities. And these resources should be reserved for activities and facilities that require a location in the tidelands. The analysis of the regulatory language requires greater scrutiny on remand, given how the Superior Court directed the regulation to be re-examined. Finally, 310 CMR 912-2D clearly indicates a preference for water-dependent ancillary facilities to be those that cannot reasonably be located or operated away from tidal or inland waters. A preponderance of the evidence demonstrates that the compressor station can reasonably be located and operated away from tidal waters.
Do you agree with everything up to the last sentence that you just read?
I'm sorry, give me 1 second just to read.
Take your time.
Yes, other than the last sentence, I agree with the paragraph.
Okay. And again, what about the last sentence? Well, let me ask you this. Do you agree with the last sentence?
No. Well, can reasonably be located and operated away from tidal waters. Yes, from a technical perspective, yes.
And I understand what you've described as the basis for your conclusion. That was an analysis of impacts to Chapter 91 waterways jurisdictions. Is that fair?
Yes.
Right. What new information do you believe you received? Not the analysis that you employed, but what new information did you receive and rely upon to reach your conclusion that the compressor station is an ancillary facility to the hub line?
The information that I received and relied upon was the accounting of the Chapter 9, of the impacts within Chapter 91 tidelands. I believe it ranged between 1.7 to maybe 18 acres, depending on the different location. That was in flowed tidelands. There were also some additional impacts that would occur within filled tidelands, but within jurisdictional waterways, there were going to be impacts as compared to the existing site where there were no appreciable impacts.
Okay. Did you review in connection with your handling of this matter the pre-filed testimony of Michael Terrell from the underlying proceeding?
I did not.
I'll just show it to you just in case it looks familiar, but I accept your representation that you did not review this. It's a 21-page document. It was signed and dated May 23rd of 2018. The reason I'm asking you is there's a review of alternative sites.
Excuse me, Mr. Hayden, could you make this document larger? Because I'm having difficulty reading it. Thank you very much. That'll do it for me.
Absolutely. So, Ms. Hops, I'm not challenging that you in fact did read this. I just wanted to give you a chance to see what document I was talking about. So, having shown you a few pages from Michael Tyrell's pre-filed testimony from 2018, is it fair to say you did not review this in connection with your determination?
Yes.
And does the applicant's pre-filed testimony concerning alternate sites, including environmental impacts and whether locating the compressor station on offshore islands have significantly greater environmental impacts than the proposed site, is that relevant to your review?
So in the interlocutory remand order directed the applicant to provide all of the information that the department needed to conduct the reviews that were directed by the two different reviews. So that was the information that I relied on.
Okay, so you're not saying one way or another whether Judge Rothschild had similar information in the administrative record before reaching her decision. Is that fair?
It was not from the department. There was not an analysis that was done to this with respect to the Chapter 91 interest by the department or by the Waterways program.
Fair enough. I'd like to turn your attention to your pre-filed rebuttal testimony, if you have that available to you.
Yes.
On page 4, paragraph 9.
Yes.
All right. Pursuant to the interlocutory remand order, is it fair to say that you reviewed the compressor station as a non-water dependent facility in connection with your review?
Yes.
Paragraph 10, you reference Chapter 8, Acts 2021. What was the reason for your referencing that statute?
It was raised in the petitioner's pre-filed direct testimony, community residents, and associated affidavits.
Okay. And same paragraph continuing on to the next page. You state that the department has fully considered the project with respect to Chapter 91 and its regulations in the context of the 2021 Environmental Justice Policy of the Executive Office of Energy and Environmental Affairs.
Yes.
And found it to be consistent with the environmental justice principles specified therein.
Yes.
Right. So am I understanding you correctly that the department did complete an environmental justice review?
I did.
All right. And what did that consist of?
It consisted of my review of the public process. So looking back to, was there additional outreach to coordinate with the EJ communities, or I'm sorry, EJ populations in the various communities? There were, I think, three translations of the public notice. The applicant provided transportation. There was a public hearing with translators. The results of the public comments, there were, I think, close to 250 individuals who submitted comments, some of them collectively. There was a hearing that had, I want to say, over 100 people in attendance. So that was in terms of meaningful involvement. That's what I was looking for to confirm that that additional outreach beyond just the standard regulatory practices had been met. And then I also looked at whether there were environmental benefits and or burdens in the context of Chapter 91.
What, I'll ask you about both, but beginning with the additional outreach, when did that occur? The outreach you just described?
I just have to look at it. Excuse me. That was in March and April of 2016.
Okay. So 7.5 years ago,
Yes,
before you joined the department?
yes,
And 2 translations, 1 public meeting, and 155 people attending, submitting 72 public comment letters. That, in your review, satisfied the department's environmental justice obligations pursuant to the 2021 Environmental Justice Policy of the EEA and Chapter 8 Acts 2021, Sections 58 and 59?
I'm not speaking to Chapter 8 Acts 2021 Sections 58 and 59. I'm speaking to the EJ policy. But yes, in reviewing the comments, there were a number of comments from civic groups and other local organizations. There were comments that were submitted by collectively and also individually local representatives, officials, state representatives. So there was definitely that additional awareness and input with respect to this project.
And again, nothing within the last 7 years.
No,
And since you cited it in your rebuttal testimony, did you, in your capacity as Assistant Director of the Waterways Regulation Program, make any effort to determine whether Chapter 8 Acts of 2021, Sections 58 and 59 imposed any new obligations on the department to conduct environmental justice review subsequent to the March 28, 2016 public hearing?
no, the project was reviewed by MEPA and determined that it did not, it didn't meet or exceed any of the thresholds that would identify it as a project likely to result in damage to the environment. And so there was an advisory opinion on the project that was issued.
Who issued the advisory opinion?
Excuse me 1 second. I think I have it. Matthew Beaton,
And what was the date of it?
July 11, 2016.
Do you know where Mr. Beaton works now?
Yeah, I think I read it in a footnote in your filing, but I'm sorry, I don't remember the name of the company, but not at a company.
TRC?
Yes,
Drawing your attention back to paragraph 10 of your rebuttal testimony, footnote 2. Do you have that in front of you?
I do.
Would you please read the first full paragraph beginning with an environmental impact report?
An environmental impact report shall be required for any project that is likely to cause damage to the environment and is located within a distance of 1 mile of an environmental justice population, provided that for a project that impacts air quality, such environmental impact report shall be required if the project is likely to cause damage to the environment and is located within a distance of 5 miles of an environmental justice population.
Do you agree that law applies to the department and the Waterways Division?
Yes,
And you agree that that law does not include a threshold limit that must be triggered to require an environmental impact report?
no,
No, you agree, or no, you disagree with me?
I don't agree. The threshold, the trigger is likely to cause damage to the environment.
Okay, but that's not a MEPA emissions threshold, is it?
These are not standards that are regulated under Chapter 91. So this process, the EIR process, is a MEPA process. The department or Chapter 91 doesn't make decisions on the applicability of these regulations to an individual project. That's done through the MEPA filing, if necessary.
But that's not what this law says. The law says an environmental impact report shall be required for any project that is likely to cause damage to the environment and is located within a distance of 1 mile of an environmental justice population. Did I read that correctly?
Yes, and the advisory opinion says that this is not a project that is likely to cause damage to the environment.
No, the advisory opinion says that MEPA thresholds were not triggered, which is not at issue in this proceeding because this is not an air permit proceeding. Let's see if we can agree on the other portion of this sentence. Do you agree that the Weymouth compressor station is located within 1 mile of an environmental justice population?
Yes.
Okay. And I believe, thank you for correcting the statutory citation on the second page of paragraph 10. Do you recall at the beginning of your testimony, you made the correction that reasonably likely or likely to cause damage to the environment is pursuant to section 61 of chapter 30 MGL, not section 60?
Yes, that was a typo.
No, and I'm thanking you for making that because what I want to show you next is section 61. Have you read this before?
I have.
Okay. Would you read the last full paragraph on
Can you make
page
it
2?
larger?
Yes, absolutely.
Thank you.
I'm just trying to line it up so we capture it all. Okay. Could you read that full paragraph for us, please?
As used in this section and section 62, damage to the environment shall mean any destruction, damage, or impairment, actual or probable, to any of the natural resources of the Commonwealth and shall include but not be limited to air pollution, water pollution, improper sewage disposal, pesticide pollution, excessive noise, improper operation of dumping grounds, reduction of groundwater levels, impairment of water quality, increases in flooding or stormwater flows, impairment and eutrophication of rivers, streams, floodplains, lakes, ponds, or other surface or subsurface water resources, destruction of seashores, dunes, marine resources, underwater archaeological resources, wetlands, open spaces, natural areas, parks, or historic districts or sites. Damage to the environment shall not be construed to include any insignificant damage to or impairment of such resources.
Okay, thank you. So do we agree that if, well, first, do we agree this is the definition of damage to the environment that applies to Chapter 8 Acts 2021 sections 58 and 59?
Yes.
And do we agree that, and I'm not asking you what the result of this analysis is, but just hypothetically, if damage to the environment was reasonably likely to be found in connection with the compressor station, because it's located within 1 mile of an environmental justice population, that would trigger the requirement for the Waterways Division to complete an
Objection,
environmental
this is a
impact report?
hypothetical.
Yeah, if you can rephrase the question, Mr. Hayden.
Ms. Hops, did you conduct any review of whether the compressor station caused or was reasonably likely to cause damage to the environment?
In the review of the materials submitted, there was no evidence that the compressor station would result in damage to the environment.
Well, in the review of the materials submitted, there was no evidence of a March 2016 public hearing either. And you reviewed that in connection with your role here today, correct?
Yes. Is there something else in the record that you're asking if I reviewed?
No, I'm asking if you made, when you indicated in your rebuttal pre-filed testimony and made the affirmative statement that in the context of the 2021 environmental justice policy of the EEA, you found it to be consistent with environmental justice principles specified therein. So having reached that conclusion, What I'm asking is, did you undertake any effort to determine whether the compressor station caused or would likely cause damage to the environment?
So the review relative to section 8, that was done by the MIPA office. The review that I did under the EJ policies was relative to environmental benefits and or burdens. So not specifically this language here that says damage to the environment in that context. Again, that was considered by MIPA as part of that the request for the advisory opinion and the issuance.
Right, but when the advisory opinion was issued, Chapter 8, Acts 2021 didn't exist yet. You agree?
Will be the last question because we're at the end of the time period. So answer the question, Ms. Hobbs. You can restate it, Mr. Hayden, because I interrupted you.
That's okay. Thank you, Mr. Chief Presiding Officer.
Yeah.
When the advisory opinion was issued by then Secretary of the EA, Matthew Beaton, now employee of TRC Companies, Chapter 8, Acts 2021, Sections 58 and 59, which you have agreed apply to the Department of the Waterways Division, were not yet in existence. Is that fair?
Yes.
Okay. I have more questions, Mr. Chief Presiding Officer, but I respect your authority to exercise time limits.
Right. Thank you. And it goes without saying, like with the other witnesses, depending on what Algonquin's and Mass DEP's respective counsel ask, by way of questioning that raises concerns that you need to address, then you can do recross on those issues, as the others were allowed to do recross. So at this juncture, I will turn to Mr. Cram and Ms. Hill. Ms. Hobbs is not a hostile witness to Algonquin, so same rule applies regarding how to question her. And I have allotted 15 minutes for any questions that you may have for Ms. Hobbs.
If it works for you, Mr. Presiding Officer, what we might do is just reserve 5 minutes and give our time to Mr. Bragg
Sure.
to spend with his witnesses, and we go again.
Sure.
Thank you.
That's fine with me. So you're reserving 5 minutes?
That should do it.
Okay. Mr. Bragg, you had 30 minutes, but Mr. Cram just gave you 10 additional minutes, so you have 40 to do redirect of Ms. Hobbs on the matters raised on cross-examination. So you can proceed.
I actually have no redirect for Ms. Hobbs.
Okay, and so then I go back to you, Mr. Cram. Yeah, since
That was
Mr.
quick.
Bragg didn't take his time, do you want to retract having taken 10 minutes off and go back to the original 15? You're free to do what you'd like to do.
Well, let's, we can be efficient. I don't think we're gonna need the entire time, but if I
Okay.
get a few minutes over 5, that would be great.
Sure. I will put it for 15 minutes in the event that 5 minutes doesn't do it for you. Is that okay?
Yes, thank you.
Sure. Go ahead.
Good afternoon, Ms. Hobbs.
Good afternoon.
Thank you for your time today. We appreciate it. Do you still have a copy of your pre-filed testimony in front of you?
Yes.
And could you open that up? And attached to your pre-filed testimony is something called Exhibit 2.
Yes.
What is Exhibit 2?
I'm sorry.
What is Exhibit 2?
Exhibit 2 is the findings of our review based on the requirements in the interlocutory remand order.
And there are 2 sections. One that's titled non-water dependent review, and the other that's titled review under any other potentially relevant provisions of the Chapter 91 regulations. Is that right?
Yes. Yes, that's correct. Both of those reviews we were instructed to complete both of those reviews.
Okay. And with respect to the second section and any potentially relevant provisions of the Chapter 91 regulations. Which regulation are you making findings with respect to?
I'm sorry, could you repeat that, please?
Yeah, so there's the second part of your Exhibit 2 concerns review under any other potentially relevant provisions of the Chapter 91 regulations.
Yes.
And I just wanted to clarify what the other potentially relevant provisions of the Chapter 91 regulations were that you're making findings under.
So we considered all of the definitions and the regulatory standards in this section. In the prior section where it says as a non-water dependent use project, we looked at only the possible, I guess, characterizations or definitions that the project would meet as a non-water dependent use, and pursuant to those standards as compared to this other potentially relevant provisions incorporated everything that the project could possibly fall under.
Okay. And so does the second section include the findings that are relevant to the program's determination that the natural gas compressor station in Weymouth was an ancillary facility to the hub line?
Yes.
And then could I just draw your attention to, on page 6 of 7, the second paragraph on that page.
Yes.
And if you could just take a moment to read that.
Yes.
And this is one of the findings that you made that was related to your determination that the compressor station is an ancillary facility to the hub line, correct?
Yes, that's correct.
Okay. And so you did consider the impacts on environmentally sensitive lands that would be associated with construction of a compressor station at any of the alternative locations, correct?
Objection
Yes.
leading.
I'll allow it. I'll just ask Mr. Cram, just be mindful of what I indicated earlier about the type of questions or form of questions to be posed to Ms. Hops.
Okay.
Thank
I'm
you.
not sure I actually, thank you. I'm not sure I actually heard the answer.
All right. Ms. Hops, if you can restate your answer.
The answer is yes.
Thank you. I have no further questions.
Sure. Mr. Bragg, I will turn back to you if you have any questions for, I know you didn't have any on the first round. Do you have any now?
No, nothing was raised there.
Sure. Okay. And Mr. Hayden, as I indicated earlier, as I did with the other council, to ask, recross, I'll allow you to do it. And why don't we go to no later than 3:30? Okay. And that will be concluded with Ms. Hops.
Understood.
Okay. Sure.
Ms. Hops, do you still have your written determination, page 6 of 7, that Attorney Cram had just drawn to your attention?
Yes, I do.
All right. In conducting your analysis of the environmental impacts associated with the compressor station, did you review the pre-filed affidavits and photographs submitted by the residents participating in this proceeding?
Yes, I did.
And did you give them any credit?
Not from a technical perspective, but I did consider the comments, the statements. The issue was that there wasn't technical or factual documented information.
Okay, there were photographs, correct, of trees and open space?
Yes,
Have you seen these photographs before?
yes. I believe that these are, yeah.
And is it relevant to you that these trees and open space are not there anymore?
I'd object. This really is going beyond the scope of the redirect and is asking her to sort of go through her entire testimony again.
Objection is sustained, Mr. Bragg. Mr. Hayden, please confine yourself to what was addressed by Mr. Cram on the limited questioning that he raised or made, excuse me.
Respectfully, Mr. Chief Presiding Officer, Attorney Cram drew this witness's attention to a section of her written determination that specifically examined environmental impacts. And I don't have any other questions. This is my only way to rebut what I believe to have been an incomplete and completely biased review that this witness has in connection with the affidavit submitted by my clients.
And I understand that, and you can ask her questions whether or not she considered the photograph that your clients presented in their pre-filed testimony affidavits. But I think questions about how she feels, whether or not about the trees being there or not, that is off limits. You ask her, please, whether or not she considered it. She'll give you a yes or no, and you can follow up with further questions. But I think, as I indicated before, it's fair game to find out what Ms. Hops relied on in making her determination. And you are right, Mr. Cram did bring attention to this portion of this document, the written determination that was attached to her pre-filed testimony. So proceed under those limitations, please.
Thank you, Mr. Chief Presiding Officer. Ms. Hops, if I could draw your attention to your pre-filed rebuttal testimony, paragraph 10.
Yes.
On the second to last page, right after your footnote number 2, there's a sentence that begins with the sworn affidavits.
Yes.
If you could read those 2 sentences for us, please.
The sworn affidavits submitted by community residents include subjective statements and identify perceived impacts and concerns about the safety of the site. These sworn affidavits do not include factual documentation of actual or potential impacts supported by technical evidence or an evaluation of the project relative to standards at 310 CMR 9.312 that refutes the department's findings, which document the project's compliance with 310 CMR 9.312.
What technical evidence do you require from a group of local citizens who say that they can no longer use and enjoy the Kings Cove Conservation Area?
Objection.
Before you will give it weight in your environmental impact consideration?
Objection. She was not stating that she was waiting for technical testimony from the resident. She was simply noting that it was not technical or expert testimony.
Objection sustained. You can move on, Mr. Hayden.
What actual impacts did you consider as presented to you by the applicant with regard to alternate locations?
With respect to the Chapter 91 impacts, those were related to the suction and discharge pipelines. And there's, I believe they range from about 1.7 to 18 acres in size, depending on the location for the different alternatives.
Right, but those impacts haven't occurred yet, correct?
No, those were what would occur if the project were to be sited in those alternative locations.
And did you ask the applicant if they could meet their criteria for expanding the ability to push gas from south to north through the hub line without damaging the environment?
Objection. That's beyond. Sorry, that's beyond the technical expertise of Ms. Hops. She's not a fluid dynamics engineer.
Objection sustained. Move on, Mr. Hayden.
Ms. Hops, there was testimony earlier today by Mr. Paquette that the least amount of damage to the environment would be the no action alternative. Did you hear that testimony?
is frozen.
Was that a yes or no, Ms. Hobbs? I didn't hear.
I think her screen is frozen.
Okay, can anyone let her know, of the three DEP council, both by text message,
Yeah.
email, let her know? I apologize, everyone. Mr. Hayden, I'm stopping the clock, the timer, because of this technical difficulty. We have 6 minutes left, so I'm stopping it.
Thank you very much, Mr. Chief Presiding Officer.
You're welcome.
I sent a message to Ms. Hobbs. Hopefully she will be able to log back on.
Yep.
My sincere apologies. Again, this is not something that's ever happened, or I would have prepared for it.
Thank you, Ms. Hobbs. We understand. So, Mr. Hayden, I'm putting the timer back on, so you have 6 minutes left for questioning, cross-examination.
Thank you very much. Ms. Hobbs, you were present this morning for the testimony of Mr. Paquette, correct?
Yes,
And Mr. Paquette testified that the safest alternative for the environment in terms of the least amount of damage is what he, in his words, described as the no action alternative.
I'll object. This is going back to an alternative analysis under FERC, and it's well beyond any questions that Mr. Cram asked on his redirect.
But again, this is focused on the environmental
Well, I
impact
just want to
review.
respond to Mr. Brett, but didn't Ms. Hobbs testify that she rejected the alternative? She agreed with rejecting the alternative sites?
I believe. Oh,
Go ahead,
I
Mr.
was
Brett.
just going to say
I'll ask you.
the basis for my question is slightly different. The redirect examination focused on that portion of the written determination that evaluated environmental impacts, and Ms. Hopp's determination that the Weymouth site caused the least amount of environmental impacts. My question to impeach that testimony is the fact that Mr. Paquette today described no action as being the safest and most environmentally friendly option, not necessarily related to alternative locations.
Oh, you can ask if she agrees with that testimony. Say yes or no, since she was present.
Ms. Hobbs, did you understand the question, or do you need me to restate it for you?
if you wouldn't mind restating it, please.
Absolutely. Mr. Paquette testified today that the safest option for the environment that would cause the least amount of environmental damage was what, in his words, he described as the no action alternative. Do you recall that testimony?
Yes, I do.
And do you agree with that testimony?
An alternatives analysis isn't required under Chapter 91 for the project. We're talking about alternatives only in the context of, is the location where the facility, the ancillary facility would be sited, required? But outside of that, there isn't a requirement to consider no action, because that's just not a standard under Chapter 91.
Okay, so you have to consider putting a facility somewhere. Is it your testimony that you, as a regulator, don't have the discretion to tell an applicant you're not allowed to build a facility anywhere as an ancillary facility to a previously?
I'll object.
infrastructure.
Again,
crossing
he's trying to insert the FERC alternatives analysis standard onto a Chapter 91 proceeding. It's simply not relevant.
And
Objection
while
sustained.
while the
Excuse me, Mr.
objection may be
Hayden.
while the
Excuse
objection
me,
may be
Mr. Hayden.
lodged,
Excuse me, Mr. Hayden. We've gone over this topic several times, and I'm going to sustain Mr. Bragg's objection. If you can move on.
understood, and I don't intend to repeat it. I just simply ask for the courtesy of being allowed to complete my question before the objection is lodged. And then obviously, as the chief presiding officer, you have the authority to stop me in my tracks anytime you like. So I'm not quibbling with the ruling. I'm just asking for the courtesy of being able to finish a question before I'm cut off and a ruling is made.
Understood, but I have been listening the last couple of minutes, and it's been in the same direction of alternative analysis under FERC. And it is in that context why I interrupted you. And,
Oh no, I apologize.
As for courtesies, I think I have been very courteous to everyone regarding time today. But why don't you continue with your questioning? And if there are any objections, I will consider them. But let Mr. Hayden finish his question for all counsel, and then I'll rule on any objection. Okay?
And
Mr.
Mr.
Hayden, move
Giordano,
on.
just so the record's clear, you did not interrupt me, and that wasn't the point I was making.
Okay, thank you. Thank you.
You very much did not.
Okay.
The objection was lodged mid-sentence from my perspective, but I don't have any other questions for this witness, Mr. Chief
Okay.
Presiding Officer.
Thank you, Mr. Hayden. I believe that concludes the cross-examination of Ms. Hops. Ms. Hops, you may step down, although you are testifying virtually. The cross-examination of all the witnesses has hereby concluded. Ms. Hops, you can remain, or you can depart, whatever suits your fancy. And
Oops, and you're muted, sir.
You're muted.
Mr. Giglio-
sorry about that. What I said is that unless council want another break, what I wanted to talk about was the remaining schedule for the adjudication of the appeal, and that is the closing brief schedule. And I think this case would benefit oral argument of counsel after all the closing briefs are filed. I did that in the Palmer Renewable Energy case, although it was a proceeding that was based on the record because the parties waived the hearing. I nevertheless found it very helpful to me to have counsel argue the parties' respective positions after the closing briefs were filed. So that is my intent to do that here. This is a very important case. It's not the kind of thing I would do in every case, but this one, I think it would benefit from having that. And we can also have the oral argument live streamed on Mass DEP's YouTube channel, as was done in the Palmer Renewable Energy matter. It was also broadcast simultaneously. So that's what I wanted to do right now, to talk about the schedule for the filing of the closing briefs. It's definitely, obviously, dependent on the filing of the transcript of today's hearing. And so what I was going to propose was that the petitioner's closing brief would be filed 30 days after the transcript is filed with the appeals office. Okay? And then I'm going to just state these, and then we can have a discussion of whether or not it'll work for your schedules. And I'm also mindful that we are entering into a period of the year with the end of year holidays, with Thanksgiving and Christmas, Hanukkah, Kwanzaa. And so and also one or more of you have child obligations, which involve schools and school vacations. So I wanted to mention that up front, that I'm aware of that certainty. So 30 days after the transcript is filed, the petitioners file their closing brief. Then 14 days after the petitioner's filing, the applicant files its closing brief. And then 14 days after that, Mass DEP files its closing brief. So I'm following the pattern how this hearing was conducted with the petitioner, going first, and then Algonquin, and then DEP last, okay? And then I would have the oral argument of counsel 14 days after DEP files its closing brief. How does that sound as a concept, both the closing brief schedule and the schedule for oral argument of counsel? I'll start with you, Mr. Hayden.
Acceptable to the petitioners. Thank you.
Mr. Cram, Ms. Hill, what say you?
I'm just looking at the calendar that puts us, I think, if we get the transcript within 10 business days of the hearing, that the petitioner's brief would be due around December 8th, and then our brief would be due around December 21, which I think is doable. I wonder if we just might move up the petitioner's brief slightly so that they don't have twice the amount of time that we will have there. I don't know if you give them 25 days and we get 14 days and we're a little bit ahead of the holidays, something like that.
Sure. I'll hear from Mr. Bragg, then I'll go back to Mr. Hayden just to see what Mr. Bragg has to say.
Sure. I suppose I wouldn't object to Mr. Cram's suggestion, although I wouldn't want it to be pushed far enough ahead that our 14 days would also run into directly into the holidays.
Mr. Hayden, how do you feel about either keeping the 30 days where it is or reducing it to a lower number?
I'm agreeable to reducing every party's number by any amount or increasing it by any amount, but I object to the reduction of the petitioner's number of days without an equal reduction to the other parties.
Okay, so why don't we do this? Because Mr. Cram pointed out that these deadlines do run into what I was talking about. Why don't I do this? Instead of me trying to come up with a schedule, why don't council confer and get back to me by the end of the week? Have a discussion amongst yourselves. You know what your schedules are for this time of the year. No point me speculating. You've all raised legitimate points. So I'll let you discuss it and then you get back to me. But include in your schedule the fact that I will do the oral argument of counsel 14 days after the last closing brief is filed, which would be Mass DEP's closing brief. Is that understood?
It is. May I ask two follow-up questions, Mr. Chief
Sure.
Presiding Officer?
Yeah.
First, do you intend for the oral arguments to be conducted via Zoom or in person?
I would do it on Zoom and have it live streamed over DEP's YouTube channel. And Mr. Fersen will be very happy with me that I will be calling upon him to do this again. So he has become an expert. Okay.
My second question is, even if the date ultimately changes, given the number of attorneys' schedules that we're dealing with, is it worth picking an arbitrary placeholder date today just so that we can put something on the calendar, and if that needs to be changed, so be it?
What I would suggest is when you're conferring regarding the schedule of the filing of the closing briefs, propose 3 dates for the oral argument of counsel. So I'll have 3 days to work with. I'll pick one of them, sort of like we did earlier this spring when I asked you folks to confer and propose alternative dates for this hearing. It worked then. I think it should work again. So by this Friday, if you folks can give me a timetable for the filing of the closing briefs and and 3 alternative dates for the oral argument of counsel. And I will repeat that oral argument of counsel will be via Zoom and will be live streamed on Mass DEP's YouTube channel. Okay. Mr. Cram, Ms. Hill, do you have any comments?
One comment, one question. I just want to say that we do appreciate as council, you're being cognizant of the upcoming holidays and the impact that they might have on council and their families and clients. That's always nice to hear. The second is I'm curious if you have a standard practice for oral arguments when you allow them and the time that we should expect to be allotted so that we can be thinking about that in advance.
Sure. I mean, I can tell you now, I don't know if it's still on Mass DEP's YouTube channel, but the oral argument I did in Palmer Renewable Energy was in October of 2021. I believe it lasted an hour total. And there, that wasn't a permit. Well, it was a permit case. It was a permit revocation case. So we only had the permit applicant, counsel for the permit applicant, and DEP. Here you would have additional. So the time frame I'd be looking at is a total of an hour, hour and a half, maybe. If that's something that council want to talk about as well, when you're conferring about the schedule for the filing of closing brief and the time and the 3 alternative dates for oral argument, if you have in mind what each side should have to argue, I'm certainly open to that. Better that all the parties agree than me having to make a decision. It's always good for everyone to agree. Does that sound good to you, Mr. Crown?
Both the benchmark and the conferring with the other council makes a lot of sense to me.
Sure. Mr. Brown, anything you wanted to add?
No, that sounds good to me. It makes sense for the attorneys to consult on a schedule.
Sure. And you're speaking for your co-counsel as well.
Yes.
So I only say that because Mr. Hopper, spoke earlier for a brief thing. I would never want to exclude him from anything. Never.
I do so advisedly since Mr. Hopper is my supervisor. So
okay.
Thank you, Mr. Chief Presiding Officer. Thank you.
You're welcome. You're welcome. It's good to have a little levity now and again. And I do not mean that to any way say that this case is not serious. It is. But we're still all human beings, right? So anyway, unless there is anything else you folks want to discuss with me, I want to thank you all that we started at 9:30 and here we are at 3:31 p.m. Not bad. Thank you all, and I appreciate it. And so I'll be looking for that filing by the close of business this Friday regarding the schedule, the filing of the closing briefs, the proposed dates of the oral argument of counsel, and the amount of time each side should have to argue their case. Sound fine to you?
Yes,
okay.
thank you.
Mr. Furson, since you control the keys to this operation, I will let you end this. Thank you. A big thank you to Mr. Furson. Mr. Furson did quite a bit. Really appreciate Mr.